My lord, in item number 2, my lord, we filed an affidavit yesterday. It has not come on record. Maybe it may be taken up on Friday, my lord. Pertains to eviction, my
My
lord.
lord, I am for the petitioner, my lord. It is required, my lord, and in that affidavit, I am also required to file a rejoinder, small rejoinder.
Friday, okay.
Friday, I can do it, my lord, by Friday. Only
Okay.
thing, my lord, is that my learned friend is assuring that no eviction.
I have already informed him, my lord.
My
On the joint prayer of Mr. A.R. Bhunya, learned counsel for the petitions, and Mr. P.N. Goswami, learned edition at Book General Assam. Release the case on
Friday.
Friday. As it is submitted that the respondent forest department has filed a counter affidavit, the same is to be brought on record.
Obliged, my lord.
1411. Wait, please, your lordship, I beg to mention item 5. Here, my lord, in item 5, grievance of petitioner 1 has been addressed and petitioner 2 has already been evicted. So matter became interrupted.
Ms. T. Shom, learned counsel for the petitioners, has submitted that insofar as the grievance of the petition number 1 is concerned, the grievance has been mitigated in the meantime.
Full stop already protected.
The petition, CS Pada submitted that the petition number 2 has been evicted from the concerned place during the pendency of the petition. And as such, the subject matter of the petition, so far as the petition number 2 is concerned, has become infectious. Post of Mr. P.N. Savil and Additional Advocate General Assam has also endorsed the said submission. Post of in view of the above submission made by Mr. Ms. Shom has submitted that in view of the above developments, the writ petition, she is not placing the writ petition. First of, in view of the above submission made by Ms. Shom, the writ petition is dismissed as not pressed.
Obliged.
May I please, your lordship, my lord, I beg to mention for listing of a motion item, my lord. Can be tomorrow, my lord.
What is the subject matter?
My lord, actually, this is that, my lord, that my biryani shop has been, my lord, seized.
Biryani shop.
My lord.
Okay, Monday.
My lord.
Biryani is not comparable to eviction.
My lord.
Monday.
Friday, my lord.
Monday.
Obliged, my lord.
But I prefer a listing on Friday, my lord. My Pattalan has been acquired for the Guwahati Ring Road project without payment of compensation.
Okay, Friday.
Obliged.
My lord, allow me to some correction in my petition. One typographical mistake.
What typographical mistake?
The one figure is, my lord, wrongly inserted.
In the body of the petition?
No, my lord, the prayer portion. Prayer portion.
File. Okay, we'll allow when the case is taken up.
All right.
May it please your lordship. As regard item number 28, my lord.
Item number?
28, my lord. They have, respondent number 6 and 7, they have filed affidavit in opposition.
28.
My lord, we need to file reply, my lord, because certain
Okay.
new developments are there.
Mr. A. Goel, learned counsel for the petitioners, has sought for and is granted. How much time?
3 weeks, my lord.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the
Respondent number 6 and 7.
respondent number 6 and 7. Full stop. Who is for the respondent number 6 and 7?
I'm respondent number 6.
Mr.
R. Sharma, lordship.
R. Sharma, learned counsel for the respondent number 6 and 7 is present. Full stop. Please the case after 3 weeks.
28 to 29.
Please the cases.
But shall I fix a date if possible, lordship?
Oh, in the read petition, huh? In the read petition. In the read petition, will you in WBC number sense. Please the cases after 3 weeks.
Shall I fix a date?
No.
My lord, another prayer, my lord. Item number 41, my lord. Can it be upgraded, my lord? My goods are being.
No upgrade in this court.
My goods are detained by.
No upgrade in this court.
My. Obliged, your lordship.
May please, your lordship. My lord, in respect of item number 40, on 6/11/2025, there is already an order to be listed on 5th December, along with 6284.
40.
40. No, 40. My lord,
List the case on 12/11.
yes, my lord. The order is over here, my lord.
Hmm?
6284 is a disqualification issue involved. Over here, my lord, last line.
This 20. You are a petitioner yourself.
No, my lord.
That case, I am the petitioner, my lord. Today's case, my lord. And that case, my lord.
What do you say?
My lord, both the case, the issue are the same, my lord. The fix on 5, my lord, 5, 12, my lord.
5/12.
Yes, my lord. Issue is the same. Here's my petitioner and that case, my lord, learned counsel is the.
Okay, Mr. E. Shali, learned counsel for the petitioner. And Mr. J. Abedin, learned counsel for the respondent number 5, have made a joint prayer to release the case on 5/12/2025, along with WBC number 6284/2025. The prayer, the joint prayer above is not opposed by the learned counsel for the other respondents. Release the case accordingly on 5/12/2025, along with WBC number 6284/2025.
Hello.
May it please your lordship, in item number 59, I have, the petitioner has filed an additional affidavit that.
Item number?
59. Motion.
Okay.
In this case, the petitioner has filed an additional affidavit that may be called for and kindly take up the matter at 2 p.m. my lord.
Serially.
May please, my lord. Item number 60, my lord, a similar prayer, my lord, I filed an additional affidavit, my lord, that may be brought on record, my lord. Item 60.
Okay.
Deeply obliged.
May it please your lordship, with the consent of the other side, I beg to mention item number 57, your lordship.
57.
Lordship, may the matter be taken up on Friday, your lordship.
Monday. On the prayer of Miss S.K. Saha, learned counsel for the petitioner, release the case on Monday.
Lordship, direct to serve the copy, lordship. They are direct to serve the copy,
Okay.
lordship.
The petitioner shall serve a copy to the learned standing council, GST,
Lordship,
by tomorrow.
obliged, lordship.
May it please your lordship, I beg to mention listing of an unlisted matter for tomorrow, my lord. It pertains to my bank account has been freezed. If it can be taken up tomorrow, my lord.
Monday.
My lord, if it can be taken up Friday.
Monday.
Much obliged.
May I please your lordship? I beg to mention item number 54. Orders matter, my lord. In this case, my lord, we are supposed to submit, my lord, amended cost title. So, lordship, after 3 days, my lord.
On the prayer of Mr.
D.
Gogoi, learned counsel for the petitioner, release the case after a week to enable the learned counsel for the petitioner to submit amended cost title.
Deeply obliged.
May I please your lordship, I am paying for upgrading item number 71. Orders matter, lordship.
After motion.
May I, lordship, simpering for listing of a motion matter, lordship, pertains to demolition. Tomorrow, if possible, lordship.
What demolition?
Demolition of their residential, lordship, saying that it falls in the for construction of the road, lordship.
Construction the road. When is the demolition notice? What is the date of the demolition notice?
Well, next week, perhaps on Monday, it will be by Monday.
By Monday, it will be demolished.
Yes, so Friday, if possible, lord.
Friday.
Obliged.
May it please your lordship, I'm on behalf, beg to mention item number 8, I'm on behalf of Mr. M.R. Sodial. He has fallen sick with viral. If the matter may be listed on next week.
Okay. On the request of Mr.
S.K. Sarfraj Karim. S.K. Sarfraj Karim.
Release the case on Monday.
I beg to mention item number supplementary 67. As told by learned government advocate, then instruction is yet to receive. So in this matter,
Instruction?
is yet to receive. That is why can it be on 3rd of December so that he can able to get the instruction, my lord?
67. Who is it? Okay, Mr. U.K. Goswami, learned counsel for the petitioner, and Mr. N. Goswami, learned senior government advocate for the state respondents are present. Mr. Goswami has submitted, Mr. Goswami, learned state council has submitted that he is yet to receive the necessary instructions to file counter affidavit. Post of and would need further 3 weeks' time to obtain the necessary instruction to file the counter affidavit post as sought for and agreed to by the concerned parties, list the case on so and so.
On 3rd of December.
High level.
Daily list for motion. Item number 1.
Hard, Mr. M. Hussain, learned counsel for the petitioner. Post. This contempt petition is deferred, alleging non-compliance of the direction made in an order dated 9/10/2023. Passed in a writ petition, WPC number 2490/2017. Post of it is ever that copy of the order dated 9/10/2023 had been duly brought to the notice of the respondents on 28/8/2024. Post of issue notice, returnable 4 weeks. The petitioner shall take steps for service of notice from the respondents by speed post within 3 working days from today.
Organized. Item 3.
Please, your lordship. Petition against the assessment order passed under the Service Tax Act. The issue involved in this matter is already sub judice before this honorable court, and the series of matters are listed for hearing.
Before which court?
Before court number 7.
7
It
tomorrow.
is already listed for tomorrow, the series of matters. So this again service matter where the point of contention is that based on the Form 26AS of the Income Tax Act, the demand under service tax has been levied. So I'm challenging that, and also that it is time barred under Section 73. Both the issues are pending in those series of matters, Lordship. So may I pray that notice may be issued in this matter and the matter may be tagged along with those.
No, put it, no, issue notice, making it returnable tomorrow. Heard Mr. A. Todi, and counsel for the petition, and Mr. S. Setiel, and standing counsel. GST.
Lordship.
GST. For the respondent number 2, 3, and 4. Postal. Then counsel for the parties have conjointly submitted that similar matters, petitions involving similar issues, are to be listed before a board in advance within brackets. And Justice S. Soikia.
Yes, Lord.
S. Soikia J. Tomorrow. And they have prayed for. And as such, they have prayed for listing of this case. Tomorrow, post of registry to look into the same. And they have released the case before the appropriate dates. Resist shall look and make an effort to release the case tomorrow before the appropriate dates.
Notice is issued. Notice has been issued in.
Who?
Notice may be issued in this.
No, I will not issue notice returnable tomorrow.
Okay.
Of life.
Item 4.
Please, my lord. This is a writ petition, my lord, challenging an arbitration proceeding, my lord, whereby the respondents had appointed an arbitrator, my lord, without considering the provisions made in the Arbitration and Conciliation Act, my lord. Whereas I have also raised my objections against the appointment, my lord.
Petitioner is in the running property in the amount of. Yes.
My lord, here the arbitrator has been appointed, my lord, without giving me a fair opportunity and without hearing me, my lord. I have filed written objection against the notice which was issued to me respect to proposal of arbitrator, my lord, which was in page 43, my lord. I have annexed the objection petition, my lord. I have received the notice, my lord, on 25th September, and within 2 days, my lord, the arbitrator has been appointed. I have received an appointment letter also. And in the appointment letter, my lord, it is disclosed by the arbitrator itself that he has earlier more than
Tell me why you have filed a writ petition.
because, my lord, my fundamental rights as well as my lord statutory
No
provision.
fundamental right. Commercial transaction. You entered into commercial transaction with respondent number 2 and 3, which is not an instrumentality of the state.
My lord,
No writ is called for.
respondent number 2 and 3, my lord, they are function in sectors like finance, insurance, my lord, which are socio-economic rights guaranteed to the citizens, my lord. Socio-economic rights, my lord, guaranteed.
No
to the citizens.
socio-economic rights. Jamaluddin to Duke. No socio-economic rights. No, Jamaluddin to Asana. This is purely a commercial dispute. Purely commercial dispute, sir.
My lord, assuming that, my lord, the respondents does not fall within the definition of state, my lord, within Article 12 of the Constitution, my lord. Still, my lord, a writ can be issued against private respondent. my
No,
lord,
discharging public function. When it discharges public function.
Sorry, my lord.
When it discharges public function, yes, 226 contemplates for any other purpose, writ can be issued. But that has been explained in hundreds of decisions when it discharges public function,
Yes, ma'am.
right?
Yes, ma'am.
Granting a loan to a commercial entity is not a public function.
But here, my lord, in excess.
No public function. Dismiss. Hard.
But further time may be given to.
No time.
But I'd like to rely upon a judgment, my lord.
Okay, give the judgment.
My lord, 2005-6 SCC, my lord.
Give the judgment. Z Telefilms. What? Z Telefilms.
Vini Limited.
Z Telefilms.
Vini Limited, my lord.
Huh?
Vini Limited.
Hard, Mr.
SS Ahmed, my lord.
SS
Ahmed.
Ahmed. Learned counsel for the petition. First, the case projected by the petitioner is that the petitioner synopsis right there, so is a proprietorship firm and it is running and operating an export-import business of limestone with Bangladesh from Karimganj district, within bracket presently, comma, Sribhumi district, bracket close, since the year 2020. Para?
29, my lord.
Post up. It is stated that in the months of October stroke November, comma 2023, the respondent number 3 offered an unsecured business loan to the petitioner for an amount of rupees 21,99,400 And the same was sanctioned on 29/12/2023. Provide loan number, লিখা আছে, synopsis. Under its PHFBLET loan facility. Full stop. After sanctioning of the loan, the petitioner paid 15 number of equated monthly installments, EMIs, regularly, amounting to rupees 4,11,939. Thereafter, on 5/8/2024, the government of Bangladesh, the government in Bangladesh was overthrown. Full stop. The petitioner has further stated that one supplier of the petitioner had also defrauded him by an amount of rupees. How much?
25 lakhs, ma'am.
Huh?
25 lakhs.
25 lakhs. Full stop. As a result, all the exports, the entire export business or the petitioner got halted. And the business operations of the petitioner was severely affected. First of yet, the petitioner continued to pay the EMIs to the petition number 2 and 3. First of the petition number 2, petition number 1, the petitioner communicated the position to the respondent number 2 and 3 by the representation dated 3/5/2025. Seeking amicable settlement of the matter, but the respondent number 2 and 3 did not pay any heed or did not pay any heed. Full stop. Subsequently, a letter dated 15/9/2025 was issued by the respondent number 4, and the same was received by the petitioner on 25/9/2025. Full stop. The notice dated 25/9/2025 was for commencement of arbitration proceedings. As the respondent number 2 made a proposal for arbitration, proposal to the arbitration, mediation and resolution council. For appointment of an arbitrator. Full stop. The notice further asked the petition to submit its opinion within 10 days. Full stop. The petitioner thereafter on 30/9/2025 submitted its objection against the notice dated 25/9/2025, objecting to the proposal for appointing arbitrator beyond the jurisdictional territory, and also sought for an opportunity to amicably settle the matter. Full stop. The respondent number 2 and the respondent number 3, 4 did not consider the objection of the petitioner as an arbitrator came to be unilaterally appointed in Pune on 27/9/2025. Full stop. The arbitrator so appointed, issued a notice for hearing along with a claim petition dated 29/9/2025, and the petitioner received the same digitally. Full stop. As per the notice, the first hearing was scheduled on 6/10/2025. Full stop. The petitioner again submitted objection before the arbitrator. We need to make a response number 5. With a copy to the response number 2 on 1/10/2025 against the appointment of the arbitrator in Pune and unilateral commencement of the arbitration proceeding, right? Arbitration case number DRBA-519A0. Full stop. The petitioner later on also submitted representations to the response number 2 and 3 for amicable settlement of the matter. Full stop. As the petitioner has not received any response or communications from any of the respondents, a petition has instituted the instant writ petition under Article 226 of the Constitution of India. Seeking setting aside of the impugned notices dated 15/9/2025 and dated 29/9/2025, issued in respect of arbitration case number DRBA 51980. Full stop. The petition has also sought for a direction to the respondent authorities to allow the petitioner to amicably settle the dispute within the state of Assam and to restrain the respondent authorities, including the arbitrator, within bracket response number 5, from passing or executing any order against the petitioner. Full stop. Para. Learned counsel for the petition has submitted that the jurisdiction under Article 226 of the Constitution of India can be exercised in a matter when there is perceived illegality and high-handedness on the part of the respondent authorities and its agents, representatives, etc. It is the contention that the respondent authorities are duty bound to follow the due procedure of law. Also, in support of his submissions, the learned counsel for the petitioner has placed reliance in a decision of the Honorable Supreme Court of India in Bini Limited and another versus B. Sada Sivan and another and others, 2005 6 SCC 657. Full stop. More particularly, paragraph 29 thereof. Full stop. The issue raised in this petition is squarely covered by a decision of this court in so instead of silo GLR court as well as GLD court as Jamaluddin versus State of Assam and others, where in a writ wherein writs in the nature of mandamus and or stroke certiorari were sought for against the a respondent, comma, Messrs. Tata Capital Financial Services Limited and its agents and appointed arbitrator. Full stop. Wherein, full stop, in so and so, this court as observed as under paragraph 9 in 11. 12, 13, 14. Para. In Bini Limited Supra, the Honorable Supreme Court has observed as under paragraph 29.
Para 11 as well, my lord. Para 11 of Bini Limited. ma'am. Para 11 of Bini Limited, ma'am.
More particular paragraph 11 and 29 there. Huh? Episode 9, 11 or 29 to 4 corrigate.
My lord, regarding impartiality of the arbitrator, my lord, I would like to rely upon two more judgments of the FX court, my lord.
The file appeal. From the relief sought by the petition in this petition is evident that the petitioner is seeking enforcement of a private contract, that is a loan agreement. Also, the enforcement of the terms and conditions of a contract which are in the realm of private law is not maintainable in the extraordinary jurisdiction of this court under Article 226 of the Constitution of India. Also, the court in its jurisdiction does not create or modify a private contract between two private entities or any private entity and a private individual. Full stop. The subject matter of this writ petition is a loan agreement executed with the respondent number 2 and 3. Full stop. The respondent number 2 and 3 is comma Messrs. Father Finance Limited is neither a entity which can be brought within the ambit and scope of Article 212 of the Constitution of India, nor it discharge any public function. First, in such view of the matter, comma, the court has found this writ petition filed under Article 226 of the Constitution of India as not maintainable. As a consequence, it is liable to be dismissed. Accordingly, the writ petition is dismissed. No order has to post.
My lord, which will be the appropriate forum, my lord?
No,
Seeking a suggestion.
knowing fully well. It is all, the writ petition is dismissed. I have not closed the other remedy.
My lord, which will be
I have not closed the other remedy. I have only said this is wastage of time.
time obligement.
Item 6.
Yes.
Look, here in this case, my lord, for requisition of our patta land.
You want similar order?
Yes, my lord, similar order will do.
Yes, madam. Page 81.
Let me. Yes, ma'am.
Hmm?
Yes, representation is pending, dear ma'am.
Where is the representation?
Representation, my lord.
Page 71.
71.
That is the reply of
Series.
notice. Yes, ma'am.
Series.
71.
My lord, representation starts from page 31
Okay.
onwards, my lord. Annexer 2 to
Uh,
14.
Heard Mr. M.A. Sheikh, Learned Counsel for the Petitioners, and Ms. M. Bormon, Ms. G. Hajurika, Learned Standing Counsel, Revenue and Disaster Management Department for the response number 1, and Ms. M. Bormon, Learned Junior Government Advocate Assam for the response number 2. Full stop. The petitioners, 13 in number, have joined together to institute the present writ petition, stating that they have a common cause of action. Full stop. The petitioners have claimed that they are owners and in possession of different parcels of land which have been
Mentioned in schedule, my lord.
which have been brought under the purview of an acquisition process initiated by LA case number 2/2025-26. Full stop. The petitioners are aggrieved by the land acquisition proceedings so initiated, under the Assam Land within bracket Requisition and Acquisition Act 1964. Full stop. All the petitioners have been served with a notice and order issued under the hand of the respondent number 2, purportedly in exercise of powers under Section 2 of the 1964 Act in the month of July 2025 bearing different dates of July 2025. Full stop. In the notices, the served upon the petitioners, the area and the description of the land which are sought to be acquired are mentioned. Full stop. In response to the notices, the petitioners have stated that in response to the notices, they had already submitted their replies individually on various dates, wherein they have raised a common grievance that in case their lands are acquired or requisition, stroke requisition, they would have no other place for settlement. Full stop. It is one of the common grievance. It is the common grievance of the petitioners that despite submission of the replies, the respondent authorities have not yet given consideration to those replies. Post op. Mr. Sikh has submitted that this petition can be disposed of in a similar manner as
Page
Oh.
79.
similar manner like WBC number 5141/2025, which was the writ petition prepared by persons similarly circumstanced. Post op. Where both Ms. Hazarika, Land Standing Council Revenue and Disaster Management Department, and Ms. Borman, Land Junior Government Advocate. Some have submitted that if such replies stated to have been submitted by the petitioners as notices, are not yet given consideration by the respondent number 2, before whom such replies were filed, direction may be given for consideration and disposal of a representation. So reply to representations in accordance with law. Post op. At the same time, they have made a contention that there was no violation of the provisions of the 1964 Act in issuing the notice under Section 3 or in Form A. Post op. Para. In view of the broad consensus arrived at by the Learning Council for the parties, in the aforestated manner, this court is of the considered view that the petition can be disposed of without giving any without dealing into the interest merits or the contention of the parties. If the representations stated to have been filed against the impugned notices have not yet been considered and disposed of. Post op. By directing the District Commissioner Dhubri, the respondent number 2, to take on board the representations of the petitioner, which are annexed as annexer
13 to 24.
13 to 24 to the writ petition, and after consideration, dispose of the same in accordance with law. Post op. It is ordered accordingly. The consideration and disposal of the representations are to be made expeditiously as it involves a project of public importance. Post op. Para. To balance the equities, page 82 the silo. To balance the equities, it is provided that till such disposal is done by a speaking order, no coercive action be taken against the petitioner. Post op. This aforesaid direction would be operative only if in the meantime the representations have not been disposed of.
Last page 82, my lord. Ill disposal, my lord. No whatsoever.
Already said.
Yes, madam. Much obliged.
No, sir.
Made please law. Under compelling circumstances, lordship, the petitioner is before your lordship.
Why 156(3) or 175?
Initially, lordship,
I think I have disposed many of your cases,
lordship.
at least 1 or 2. in similar circumstances?
No, not my case.
Not you. Yes,
Let them
no
take-
magistrate.
And let it be on side.
No, this is to be disposed of.
Let them take.
We are not entering, no?
No, Lordship, what happens, there is a peculiar fact, this person,
No
your
peculiar
Lordship,
facts.
he has been threatened by this person. Now, to such an extent, he is saying that even police or magistrate, nobody can do to anything to him.
That
He
is
has-
why you go to the magistrate.
He has brother advocate, your Lordship, and if he goes to the court, your Lordship, there is fear to his life and life also, your Lordship. Lordship will kindly see the complaint he himself had written, your Lordship. Otherwise, I would not have come before this court. Or let them take instruction whether any affair they have registered, your Lordship. If registered, your Lordship, then there is nothing. And if not registered, at least they can consider the representation, your Lordship. Which he had.
Why should we enter into those?
No, because if the
Strongly deprecated time and again
Lordship is otherwise I
for
don't have-
entertaining this kind of writ petition.
Lordship knows, your Lordship, way back in 2013, Lalita Kumar judgment, the Supreme Court has said that if the complaint discloses a cognizable offence,
That is why-
it is for the police to mandatorily register the FIR.
Right,
Then
not
there is
done,
a-
then magistrate will do.
There is an alternative that if the OC does not register, he will have to go to the superintendent of police, which he has done here.
And
also.
then thereafter, what is
Then
the
your
third
Lordship,
option?
magistrate is there,
And
but
then-
he is
then-
threatening him to such an extent, your Lordship,
You are saying that you cannot go to the magistrate also.
because he said that he has brothers there.
Make a
as an-
statement. That you are afraid of going to the magistrate also.
That statement I have not made,
Huh?
but that is what I have been told, your Lordship. Kindly see the last
No, I am not going.
complaint
to
that he has filed, your Lordship. This is
We will observe these thousands of writ petitions are going to, this High Court will be flooded with thousands of writ petitions. That is the comment. So,
when the incident, Lordship,
Sakari.
that he has mentioned, your Lordship, it is videographed, your Lordship, in the
নতুন judgment to Sakari to sound.
he's saying that police cannot do anything to him. He goes to the OC does not register his case. He goes to the SP does not register it. There is a videograph, your Lordship, which shows the whole incident, your Lordship. The news report was also published in the local media, your Lordship. In the local channel, your Lordship. News channel.
This is in Sudhir Bhaskar Rao Tambe. We are of the opinion that if the High Courts entertain such writ petitions, then they will be flooded with such writ petitions and will not be able to do any other work. Strong words, except dealing with such writ petitions.
Generally, nobody comes, your Lordship, to the High Court.
No, I have dealt with more than 200-300 cases. Everybody comes at a drop of a hat. So time has come
Consider the
also to impose costs sometimes.
Lordship will kindly see the complaint.
Heard
that he has-
Mr. M.
that he has submitted,
Loskar, learned counsel for the
13.
petitioner. And Miss M. Borman, learned junior government advocate Assam for the responding number. For all the respondents. First off. Para. The petitioner has claimed that he is running a business from a shop, from a rented shop, since 2000, 2017, 2018, in a name and style of Master Sri Guru Bostrala. The shop is located at Kalapahar, Bhaskar Nagar, Guwahati, District Kamrup Metro. Post office. The petitioner has alleged that since starting of his business, a person from the locality has been harassing him by demanding illegal protection money illegally. First off, the petitioner stated that initially, he gave the money out of fear for life and property. First off, recently, the said person demanded an exorbitant amount of rupees 10 lakh Full stop. When the petitioner refused to provide the same, the said person accompanied with either use with the petitioner had given a beating to the petitioner. Full stop. The petitioner further stated that when the petitioner said, when the petitioner told him that he would call the police, the said person said that he had good connection with the police, as his brothers are in police and are lawyers. Also, the petitioner has stated that he initially lodged a complaint before the respondent number 4 on 16/2/2025. Went to lodge a complaint before the respondent number 4 on 16/2/2025. Post op. As the respondent number 4 refused to receive the complaint filed by the petitioner, the petitioner submitted a written complaint online in the Assam police portal. Post op. As the same remained without any response, the petitioner approached the respondent number 3 by way of a written complaint dated 17/2025. Full stop. As the written complaint dated 17/2025 also has not evoked any response, the petitioner is before this court by the instant petition seeking inter alia direction to the respondent authorities to register the complaint submitted by the petitioner as an FIR, first information report forthwith. Full stop. Yeah. The petitioner has an appropriate BNSS conduct, has an appropriate remedy.
Instead of registering your lordship, let the
Under section 156(3) of the Code of Criminal Procedure 1973. And alternately under section 175. Within bracket 3, read with section 173 within bracket 4 of the Bharatiya Nagarik Suraksha Hunita, 2023. Full stop. Para 7, 8. 9, 10. 11. Para. This court is not entering this petition. In view of the following observations made by the Honorable Supreme Court of India in Sakiri Basu versus State of Uttar Pradesh and another reported in 2008 to SSC 409, para 4. Next, the observations made by the Honorable Supreme Court of India in Sakiri Basu versus Supra have been reiterated in the subsequent decision in Sudhir Bhaskar Rao Tambe in the following manner, para 5. In a recent judgment of the Honorable Supreme Court of India in Om Prakash Ambedkar versus State of Maharashtra and other 2025 INSC 139, the Honorable Supreme Court has brought out the distinctions between and has brought out a comparison of section 175(3) of the BNSS with section 156(3) of the CRPC in the following manner, para 31. Para. In view of the availability of such appropriate remedy available to the petitioner under subsection 3 of section 175 of the BNSS 2023, and in the light of the observations of the Honorable Supreme Court of India in Sakiri Basu Supra and Sudhir Bhaskar Rao Tambe Supra, this petition seeking the above direction is not entertained, reserving the liberty to the petitioner to avail the remedy of aforesaid remedy before the jurisdiction magistrate under section 171 before the jurisdiction magistrate. Full stop. While not entertaining this writ petition, this court would like to clarify that this court has not expressed anything on merits as regards the allegations made in the complaint by the petitioner before the respondent number 3 and the respondent number 4.
Obliged. Item number 9.
May it please. Lord, the private respondent had raised certain illegal constructions, my lord, which is why we had approached the Mangalore Municipal Board, my lord. After inquiry way back on 19/4/2021, the order your lordship finds at page 24, the illegal constructions were directed to be demolished, my lord. That order has not been implemented till date, my lord. In fact, in the course of the last 4 years, my lord, they had approached the circle office of a demarcation. Circle officer also clarified that Mangalore Municipal Board can go ahead. They again appealed against that order. That order was again affirmed. They thereafter instituted civil suit seeking injunction. That was also declined, my lord. But nevertheless, that order of 2021 is yet to
They are
be.
your neighbors,
Yes. The commercial.
relatives,
My lord?
relatives.
No, not relatives. It's a very cramped area, so therefore.
Heard Mr. B.D. Rekha. Learned counsel for the petitioner. Housing Urban. Miss M. Morman, learned junior government advocate Assam for the respondent number 1. Any
Private-
three also. 3 also?
3.
Okay. Any standing council? Mangalore Municipal Board? No.
To my knowledge.
Agree by inaction on the part of the respondent Mangalore Municipal Board authorities to act on their own demolition notice.
Yes.
The petitioner has approached this court by the instant petition. Post of issue notice returnable on so and so. As Ms. Borman has appeared and accepted notice on behalf of the respondent number 1 and 3, issuance of formal notice to the said respondents stand dispensed with. Extra copy of the petition within 2 working days from today. The petitioner shall take steps for service of notice upon the respondent number 2, 4, 5, and 6 by speed post within 2 working days from today.
No, pendency will not be a bar for them to implement. No, pendency will not be a bar.
We don't know. Let us see. No. Right.
10, 12. Item number 10.
May I please, Lordship, impugned notices on 34, my lord.
Only 12,000, you say?
Lordship.
Dubious transaction is only 12,000.
It might.
Huh?
Yes, my lord. Only 2,000, my lord.
You are a senior citizen,
My lord, pensioner,
pensioner.
my lord.
Any standing counsel? Why you have made Reserve Bank of India party unnecessarily?
And then,
We're not issuing notice at this stage.
State Bank may be case. State Bank of India, my lord.
Is there any standing counsel, State Bank of India?
Yes, my lord. State Bank of India.
Who? Otherwise, you have to issue notice, returnable 4 weeks. Yes, Mr. Das, are you aware? Any? Who?
Forgot his name, my lord.
Huh?
I failing to recollect his name, my lord. Sometime I can.
Find out any standing counsel is there. Your thing can be expedited on then only.
Room number.
Item 11.
Days.
May I please, Lordship? Lordship, impugned notices on page 34, my lord.
Huh?
Page
What is
34
the
is
case
the
about?
notice, my lord.
Residents of Kendua, Sohan, Jayantipur, Paharpur, Karora, Kamalpur Revenue Circle. Khotian, entries, conference. Your occupancy tenants.
Yes, my lord.
Huh?
Yeah, Khotiandar, my lord.
Huh?
Khotiandar, yeah.
Khotiandar. Khotiandar is occupancy tenant.
Yes.
Where their respective residents situated in a sale land. In the last week of January, there a discussion in presence of so-and-so, recording the continual long-standing claim for allotment of, however, in response to an application, laundry case number so-and-so, submitted by grandson of one of the original pattaras, the private husband of 4, the circle officer issued a hearing for demarcation of settlement. Where is that notice?
Notice page 34, my lord. Banaplar is.
Okay, and thereafter, notified and notice. What, how is the apprehension? What is the apprehension?
Lordship, this.
This notice does not indicate about, cannot give rise to any apprehension.
Issuance of patta, Khotiandar, my lord, he'll be remain as a Khotiandar. If he cease to be Khotiandar, the DC has got power to appoint someone as the Khotiandar, landless people who can cultivate it. But issuance of patta to a Khotiandar.
What is the temporary, what is the act?
Temporary settle, Assam Temporary Settle Acts, Tenancy Act, my lord.
If you are Khotiandar, you can claim.
They will remain as a Khotiandar.
No, they
And
can,
if they cease to Khotiandars, my lord, some.
no, they can claim the status if really they are Khotiandars.
Yes.
Is it not?
Yes, Khotiandar
Adverse to the owner.
always will remain as a Khotiandar. But issuance of patta in their name set. That is my
That
lord.
requires a procedure, they can claim. I think there is provision, is it not? For occupancy tenant? And without following that, number certain occupancy tenant case 200. Case 254. If you are Khotiandar, then you are you have acquired occupancy rights.
Lordship.
Then if you are occupancy tenant, then you have permanent, heritable and transferable right of use and occupancy in the land.
of his holding,
Yes, my lord.
right?
That-
Permanent.
That is what, my lord.
That is
If
what
he
it
ceased
said.
to be an Khatyandar, my lord, DC has got the power to appoint someone, the landless people, as a Khatyandar.
Then thereafter,
In the notice, my lord,
My lord,
the original pattadar, my lord, claim demarcation, my lord.
only the demarcation.
thereafter,
Page 34 is only the demarcation.
21. Notwithstanding anything to the contrary in any law, custom or agreement, an occupancy tenant personally cultivating the land of his tenancy shall be entitled to acquire the rights, titles and interests of his landlord. Hereinafter called the ownership rights according to the provisions of section 23. So where your occupancy right has been disturbed, if you are really Khatyandar,
Yes, my lord.
you are claiming to be Khatyandar, then under section which I have just read, 6, incidence of occupancy right. An occupancy tenant shall have permanent, heritable, and transferable right of use and occupancy in the land of his holding, subject to the other provisions of the Act.
This notice, my lord, no cause of action arose, my lord.
No cause of action for what? If you are really Khatyandar.
Lordship, hearing,
Pattadar, this is a misnomer. Maybe if you are Khatyandar, then it is okay.
Lordship, sir, hearing was called on my lord, 12/3/2025. My
We
lord.
are not, actually, I am not finding any
Thereafter, my lord,
apprehension. And it is a notice for demarcation only.
Yes, my lord.
Huh.
What is the outcome?
Then
of
your
the-
right will be more crystallized
Yes.
rather than the apprehension.
Yes, ma'am.
Actually, it is for your benefit.
Lordship,
Think it over. It is for your benefit. Your holdings will be finalized. Then you can claim against this respondent number 4 if he is the landlord.
yes, ma'am.
Make an application under section 23. Get your occupancy Khatiyan converted into periodic patta. Go through the provision, then come.
Another date may be fixed, my lord.
On the prayer of request of Mr. S.B. Laskar and consider the petition, I'll raise the case on next Wednesday.
Must do.
Read it. I think it is for your benefit only. Mr. Ayan Das, Learned Junior Government Advocate, Assam for the state respondents. Is independence.
1911. Item 12.
In this matter, my lord, the instruction was called for them.
Well, this case was, my lord, moved as unlisted on 7/11, my lord.
Okay.
Then, my lord, though the matter was taken up, my lord, the records were not available, my lord. So, Honorable Justice Edith Chaudhary, my lord, instructed me to take instruction, and they also said that they should not be evicted because eviction was scheduled on 9th, my lord. So,
9th of November.
So I gave an undertaking, and they also said that they should be allowed to remain in there for 10 days. So these two are instructions, my lord. His basic claim is that, my lord, they have
three petitions.
Three petitions. The basic claim is that, my lord, they had earlier filed a writ petition wherein a direction was passed to, my lord, consider their representation pursuant to the eviction notice. That they submitted. If my lord pays 30 of the writ petition, my lord. Several others also join in that writ petition, my lord.
They are out of them.
They are out of them. Earlier it was, my lord, total petitioners were, my lord, for 59.
59.
If my lord.
So these three petitions are
among them, my lord. So if my lord peruses last page, my lord, 37. Under such circumstances, issuance of a notice shall be necessary to form a subjective satisfaction which is in consonance with the principles of natural justice, inasmuch as the same will facilitate a just, fair and transparent procedure which are facets of Article 14, 19 and 20 of the Constitution of India. In view of the aforesaid and the stand taken by learned so and so, this court is of the opinion that the petition can be disposed of by directing the respondent forest department to consider the representation of the petitioner. The petitioners may also file fresh representation within 10 days from today before the office of the DF, District Forest Authority, Goalpara. They filed a representation, but that was answered, my lord, which is impugned in this proceeding. That my lord finds at page.
They filed a representation.
File a representation. Some of them actually filed earlier also.
These three,
These three, my lord, filed representation.
Huh.
Those were considered, my lord, and this is an order in respect of the petition number 1. But that on this one they have annexed. We have rejected their claim and we have found that they are residing inside the forest. My lord, first 3 paragraphs are, my lord, preceding facts, my lord. If we go to, my lord, second last paragraph, page 28. And whereas the Dohikota Reserve Forest was notified as Reserve Forest by government notification number so-and-so dated so-and-so under the provisions of Assam Forest Regulations 1891. And whereas upon detailed evaluation and consideration of the representation submitted by Sri Robiul Hussain and also upon consideration of joint verification report dated so-and-so and so-and-so and relevant forest record, it has been clearly established that the claim lacks any documentary or legal basis and the land under occupation and encroachment wholly lies within the notified boundary of Dohikota Reserve Forest, which was duly notified by notification dated 5/4/1973 under so-and-so. Further, as per chapter 2 of the so-and-so, these are, my lord, finally, my lord, last paragraph. Now, therefore, after due consideration and in exercise of powers conferred under section 24, 25, 72 of Assam Forest Regulations 1891 and read with the directions of the Honorable Guwahati High Court in suo motu PL so-and-so, read Appeal 251, 252, it is hereby ordered. The representation submitted by the notice is found to be baseless and devoid of any merit, and it is absolutely clear from the records that the noticee is an encroacher within the Dohikota Reserve Forest. The noticee directed to vacate the forest land on or before 8/11/25, which marks the completion of 30 days from the date of original eviction notice. In the event of failure to vacate within the stipulated time, the eviction process shall be undertaken. This was assailed in this proceeding, my lord. Then, my lord, there was some deliberation due to paucity of time. No order was passed, my lord. I was also present. So I wrote to the authorities what was the deliberation on that, but there is no specific order to that effect, my lord. I was present, my lord. The Honorable Court asked me verbally to communicate that they should not be disturbed for 10 days. In the meantime, my lord, if possible, to go for a fresh verification in respect of them. Because what they are saying, my lord, they say in between the forest and their land, there is a PWD road. And according to them, that PWD road is the boundary. So they are beyond the boundary of forest. That is their precise claim, basically. And before that, my lord, before taking to the instruction, page 30 for a moment, my lord. The earlier order passed in the earlier repetition, my lord, 6217. They cannot also say that, my lord, we have done it mechanically. That is to show that, my lord, page 30, this is a party structure. Page serial number 126, my lord. Of the same repetition.
126.
126. We found them to have, my lord, Patta land, my lord.
Okay.
So they have been specifically excluded by orders passed, my lord. But in respect of the petitioners, my lord, my lord, may kindly peruse my letter to the DFO, my lord. This will give the background, my lord, of the last proceeding, last date, my lord. With reference to the subject cited above, it is to inform you that the aforesaid repetition has been filed by 3 petitioners, namely Robiul, Mallika Khatun, and Insaf Ali, assailing an order dated 6/11/25, whereby the claim of the petitioners for residing outside the notified boundary of Dohikota Reserve Forest has been rejected and are directed to vacate the occupied forest land. These 3 petitioners, along with 56 others, earlier instituted WPC 6217 of 25, wherein the Honorable Guwahati High Court, by order dated 3/11/25, directed the Forest Department to consider the representation of the petitioner. It has been contended by the petitioner that though they have submitted representations dated 6/11/25, same has not been properly considered. In their representations, they have taken a specific plea that they are in possession of government khas land situated at Dubapara, Luptachar, under Bhotiapara revenue area.
Paragraph 4, I think. Paragraph 4.
Yes, ma'am.
They have given a table.
Yes, madam. Which, according to them, lies outside the notified boundary of Dohikota Reserve Forest. According to them, the description of the boundaries as per notification dated 5/4/1973 indicates that the Gwalpara-Matia PWD road forms the forest boundary. The aforesaid repetition, though, was taken up for consideration. However, due to paucity of time, no effective order could be passed by the Honorable Court. However, the Honorable Court has requested the undersigned not to evict the petitioners for another 10 days, as the petitioners have also agreed to vacate the land occupied by them within that period. The Honorable Court has also verbally requested the undersigned to cause one more inquiry about the specific claim of the petitioners about their land falling beyond the PWD road, which according to them is the boundary of the reserve forest. Now, my lord, they have again caused an inquiry, my lord, and this is the outcome, my lord. From the paragraph, my lord, consideration of representations. Their representations were duly received and examined along with the revenue officials during the joint verification conducted on 2 and 3rd November. Findings we may come to, my lord. Based on the above, the speaking order dated 6/11/25 was issued by the office rejecting their claim and directing them to vacate the enclosed forest within the stipulated period. Compliance with the Honorable Court's verbal direction. In compliance with the Honorable Court's verbal observation conveyed through your letter, the relevant notification description of Dohikata Reserve Forest dated so-and-so was revisited. It was found that the Gwalpara Matia PWD road mentioned therein passes through the Dohikata Reserve Forest, and the area north of the said PWD road falls within the notified boundary of Dohikata RF. Hence, the claim of the petitioners that their land lies beyond the RF boundary and outside the forest is factually incorrect. Next page, well, if we turn, last page, my lord. The map, my lord. The straight line, my lord, going from top to bottom, my lord, not straight line, it's the PWD road, my lord. Above that, my lord, you'll see there are 3 pins, including the names, my lord. Nisab Ali, Robiul Hussain, and at the top, my lord, Mallika Khatun. These are the area of their residence. And my lord, you'll see at the left-hand side, my lord, from the road, where the road starts, this is the map, my lord, of the forest that also runs through the road. Then it goes up, my lord. Northeast. It goes northeast, the map, my lord. Boundary map. Then above Mallika Khatun, again, it goes eastward, my lord. Then southward. This portion of the PWD road, my lord, is inside the forest, my lord.
This road is inside forest.
Not the entire, my lord. After that, my lord, we'll see at the left-hand side, my lord. It goes, the boundary goes southward, my lord, and the road goes straight, my lord.
Dohikata Reserve Forest.
Yes, ma'am.
RF boundary. RF boundary is which one?
RF boundary, my lord, initially it starts with the road from top, my lord, top. Then it goes up, my lord, northeast direction, my lord. Then it goes again up, covering Mallika Khatun, it goes eastward, my lord, then it comes south.
The small line.
The small line, my lord. The big line is the
smaller one. Smaller
one. Big line is the road, my lord. Smaller line is the
another road.
That's the map. That's the boundary of the forest, my lord.
For the white one. White
one that goes up, my lord, and again comes down.
Yes.
This is how their area comes under reserve forest, and everything at the south, my lord, is the forest, my lord.
So this otherwise, except this part, the
top,
other part goes along with the boundary.
Yes, my lord.
Of the main road.
Main road.
Gwalpara Motia Road.
Yes, my lord.
Except this part.
Yes, my lord.
Wherein Dubapara Park, Robiul Hussain, Insab Ali.
Yes, my lord. These are inside the forest, my lord.
Moha, some Vidyapit.
Yes, my lord.
This part comes within
the forest, my lord.
Forest.
That's the forest boundary above this, my lord. Just going above Mallika Khatun.
Yes, what to do?
This.
Where from you are saying it is government fast land?
It is
Because only that's last one submission. Because that's a PWD road, they are of a view that road is beyond the forest. There are so many instances, my lord, including in Kaziranga, my lord, has seen the national highway runs to the national park, my lord.
Now, where from your claim arises? This government fast land?
Page
Any land document?
Page 19, my lord, Annexure 2, my lord. This is the notification, my lord. Where, my lord, the clearly description of boundaries, my lord. This is contributed to the.
Tell me
joint
which one?
verification.
Page 19.
Page 19, my lord. Number 2, description of boundaries, my lord. Reference point, pillar number 1 is fixed at a distance of 20 meters with a bearing of 157 degree from the long post of 8/5 on the Gwalpara Matia PWD road. Reference point, pillar number 1 is 20 meter away from the PWD road.
Now, what is your claim regarding government fast land? Do you have any revenue records?
Yes, my lord, we annexed, my lord,
Oh, Khazna, don't rely on
is,
Khazna receipt.
page 15, my lord, page 17, my lord.
Don't rely on
This is
Khazna
the-
receipt. Any Chita.
Chita, I will
Chita,
produce, my lord. Next
revenue
week, my lord.
records.
Chita is there, my lord. I will produce, my lord.
That your land is shown as government khas land.
Yes, my lord, Chita is there, my lord.
Huh?
I produce, my lord, Chita.
Yes, their claim is government khas land.
We have verified with the joint verified with the revenue authorities twice, my lord. Well,
Ah.
let
That is the
let him
term,
bring it on Friday. I will file an affidavit, my lord.
Normally, once it is declared a reserve forest, how it is to be recorded in the revenue records?
It will be recorded as forest land. Once it is notified, my lord, revenue will give up their claim over the land, my lord.
Because then
Settlement
some land and revenue regulation will not
will not
be
applicable.
applicable.
Section 4, my lord,
Ah.
specifically excludes.
So
And-
it excludes.
And in the meantime, my lord, when the proposed RF is declared, my lord, at that stage, my lord, the settlement officer decides all pending claims.
All pending claims. When if it is not made, then everything goes.
Goes, my lord. And later on, nobody can have a claim.
Nobody can have a claim. So, Mr. You're only limited.
And they themselves, my lord, do not record it, my lord. I was there, said they should be allowed 10 days time to go out. And court requested me to cause an inquiry for their satisfaction, my lord. Clearly.
Now it is within the boundary as certified by circle officer also.
It is,
Right.
lordship.
Now, unless you say something that your land is recorded as government khas land, you are in occupation of that.
I will produce the Chita, my lord,
Ah.
on next date. And
Friday.
annexure, my lord, 3 may be seen, page 24, my lord. Earlier they were tried to plantation on that land, my lord. Circle officer, my lord, on field verification, it is found that, my lord, this is the revenue land, my lord.
Huh?
In 1987, my lord, annexure 3, my lord. Page 24, my lord.
None of you are in 78. None of you are in Dag number 78. As per your own table,
Yes, sir.
paragraph 4, your Dag numbers are different.
My different, my lord.
But this letter does not give any benefit to you. It is only 78.
This is the Batiapara village, my lord.
Batiapara maybe
Yes, my lord.
78 Dag number.
Yes, my lord.
ঠিক কথা so and so ষোল্ল লেচা অংশৰ দুই so and so ষোল্ল লেচা মাটিত বন বিভাগে বিভিন্ন গছ ৰুই আৰু তাৰ কাটাৰে জেউৰা দি দখল কৰি আছে only and your area is much bigger. It is how much? 2 বিঘা 2 or 3 katha 16 lesser. Maybe. But that is Dag number 78. Your Dag number is 422508889.
89.
So Chita
Chita will produce.
only
next
your
week, my lord.
Chita Friday.
Yes.
Just inform that no action against these 3.
Yes, we are not taking, but in fact, my lord, on 9th, entire eviction was done, barring
These
them.
3 are remaining.
Yes. Well, do I need to file an affidavit, my lord? This will suffice. Should I file them? Okay.
Then should it be on Friday or Monday?
Monday, my lord.
Monday. Heard Mr. S.B. Loskor, and counsel for the petitioner, and Mr. E.M. Gusami, learned additional advocate general. Some listed by Miss M. Kolita, learned counsel for the all the respondents. All the respondents. Also. Mr. Gusami has submitted that subsequent after 7/1/11/2025, comma Like after filing the repetition, comma, a verification exercise was undertaken. For determination of the boundaries of Dohikata Reserve Forest. And verification was in correlation with geo coordinates based on the notification dated 5/4/1973 and the physical boundary marks. In the joint verification and demarcation process, it is found that the parcels of land claimed by the petitioner are found to lie within the notified boundaries of Dohikata Reserve Forest. During the verification process, the petitioners could not produce any valid patta or evidence of their lawful position or of their position over government khas lands outside the reserve forest area. The finding. Mr. Goswami has submitted that the finding is recorded by what does it call? Map. What does it call?
Listen, this
Map
is
showing
map showing
RF boundary, PWD road and location of the dwelling houses of the petitioners.
jointly endorsed by Forest and the Revenue Authority.
Jointly endorsed by the Circle Officer, Motia Revenue Circle and Divisional Forest, Range Forest
Range
Officer,
Forest, Gwalpara.
Gwalpara Forest Division. At this stage, Mr. Roskar has sought. Mr. Goswami submitted that the matters, no, the stand and the finding of the Forest Department authorities will be brought by you of an affidavit. By Friday you'll file or Monday?
Friday and second file.
On or before Monday, huh? Monday. Monday is 17. At this stage, Mr. Roskar has submitted that he will make endeavor to produce documentary evidence in support of the petitioner's claim in the form of cheetah, etc. on the next state of listing. As agreed to, I will learn counsel for the parties, list the case on Monday, 17.
All right.
We're not observing anything, you just keep.
That I will answer in my problem.
Lordship, in this case, Lordship, the petitioner number 1 is the owner of the land and the petitioner number 2 is the prospective seller, Lordship.
Submitted application for NOC.
Yes, Lordship. And here, Lordship, the when petitioner was informed that.
Yes.
They have challenged the notification, Lordship. Annexure 7, page 50.
And I am challenging this notification also, Lordship.
Page 50.
Page 50.
Yes, Lord.
Page 50.
Okay, what are the
New
grounds?
notification, Lordship,
Hmm?
regarding the inter-religion land transfer.
I am challenging this notification also on the ground that, Lordship, this notification is based on religion, Lordship, and as the government created classification among the own citizens, Lordship, by formulating different formulas, Lordship. For one set, Lordship, this formula, Lordship, applicable, and one for another set, Lordship, the another set is applicable, Lordship. And
Okay.
that is, Lordship, unconstitutional, Lordship. And
Is this notification under challenge in any other petition?
Lordship, there is
Yes,
another
Lordship.
cases there, Lordship, where
Notice was issued, no? 5896. 5896 Minaxidas. Notice. Issued, when you get it.
Okay, let it be with this one also. Heard Mr. AMS Mozumdar, Learned Counsel for the petitioners, who are agreed by a notification dated 9/9/2025,
25.
annexed as annexer 7 to the writ petition, first of, formulating SOP for inter-religion transfer of land, first of. In this writ petition, the petitioner is number 1 is the intended seller and the petition number 2 is the intended buyer.
Lordship.
Issue notice returnable in 4 weeks. As Ms. Hazarika, G. Hazarika, Standing Counsel, Revenue and Disaster Management Department for the respondent number 1,
1 and 2.
1 and 2, and
3, 4, 5.
and us, Land Engineer Government Advocate, some for the respondent number 3, 4, and 5. As Ms. Hazarika and Mr. Das, extra copies within 2 working days. The Learned Counsel for the parties have submitted that the notification dated 9/9/2025 has been made subject matter of challenge in another writ petition, WPC number 5895/2025. This is the case after 4 weeks along with WPC number 5895/2025.
5896.
96.
Apply.
Item number 14. Yes, Lordship. What is here in this petition, my lord?
Died leaving behind some land and property which was not meted at the relevant time.
As per requirement, they are demanding the Aadhaar card of 1993 when it was not in the process, my lord. But I am unable to apply for the petition also. I have submitted it.
Your father purchased land.
Yes, my lord. But
Have you
my,
mentioned the
Yes,
sale leads?
yes, my lord.
Have you mentioned the sale leads?
Yes, my lord. Send it.
Which one?
I have mentioned by the copies I'll produce, my lord. I believe the court.
Who will produce? When will produce?
Page 19, my lord.
Page 19.
Yes, my lord. This is his representation, my lord.
I have the honor to inform that my late father purchased land. Have you annexed?
My lord, this is a,
Which land?
Nothing.
By which sale deed?
my lord, I have the.
When?
Yes, my lord, I have, but this is a,
That is inside the brief, not before the court.
yes, my lord,
One more, it was, this representation was filed on 17/10. Hardly not 1 month or something. Some reason.
This is, how can the court will, the authority will examine
Exactly, my lord.
your claim?
my lord, I'll produce by next date, my lord. This is all the records in the local.
Authority that is unable.
Oh, we are not here to examine your case.
My lord, let me submit. My lord, fact is that they are not even allowing to show anything there of my lord. That is why I have come before you to,
File an appropriate application
and.
along with all the details. Your father purchased
Yes,
it,
yes, my lord.
right?
Yes.
By a sale deed. This
Yeah.
is the description of the lands. This is very vague. How can we act?
Yes, yes, my lord, I will submit, but only the fact is that, my lord, the basic requirement, they said regarding Aadhaar card of 1990, my lord, that time there was no.
No,
other-
first time you see, you read this
Yes,
representation.
I admit, my lord, I admit.
Read this representation.
Yes.
Read.
I admit, my lord, this is not complete.
What kind of land, which land, when purchased,
I'll
who is
submit.
your father, how he purchased? Nothing is there.
My lord, I will submit.
Maybe he has failed to mutate the land,
Yes.
but at least the land particulars should be there and the land deed.
I admit, my lord.
Sell it.
This is not complete, my lord.
Ah.
I will do, my lord.
You make a fresh representation.
Yes.
Okay, your grievance that they are not accepting the representation.
Yes, my lord.
We'll observe,
Yes.
right?
Yes, madam.
Heard Mr. A.U. Chaudhary, learned counsel for the petitioner, and Mr. Miss G. Hazarika, learned standing counsel revenue department for the respondent number 1, and Mr. N. Das, learned junior government advocate Assam for the respondent number 2 and 3. Poster. According to the petitioner, his father, late Abdul Sattar Chaudhary, purchased a parcel of land measuring 14 khatas, 3 chataks, and 10 gandas, para 2, from one late Sofikur Rahman Chaudhary, and another parcel of land measuring 5 khatas, 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 from one late Faras Uddin Chaudhary through different sale deeds at different times. Post to the parcels of land so purchased are situated at village Rangauti Part 2, Post Office Rangauti Part 2, District Hailakandi, prior to his date on 31/12/1993. Post of. In addition, the petitioner has stated that apart from those parcels of land, the petitioner himself had purchased another parcel of land measuring 22 khatas, 11 chataks, 10 gondas from his co-sharers, including his mother, etc., in the year 1996. Post of. A petitioner has further stated that his father could not mutate the parcels of land he had purchased prior to his death. Full stop. The petitioner approached the respondent authorities, more particularly, the respondent number whom?
2, my lord.
2
Yes, no.
or 3
2, my lord.
respondent authorities. Or mutation of those parcels of land by UFA representation dated 17/10/2025.
Everyone is there. It's other open.
Post of the petition has submitted that the representation has to be, application has to be submitted online because of their refusal to receive a physical application, receive an application physically. Post of. The petition has further contended that for mutation of the land, the respondent authorities are insisting for Aadhaar card.
PAN card.
And PAN card.
Aadhaar
and PAN.
PAN card of his late father. Post of. Or father, whereas at the time of his father's death on 31/12/1993, there was no provision for issuance of any Aadhaar card. Post of. But be it as it may, when the application, stated to have been filed by the petitioner online on 17/10/2025, contents of the are perused, it is found that
the application is bereft of bereft of the details, description of the parcels of land which the petitioner's father had purchased prior to his death, as well as the description of lands the petitioner had himself purchased. Full stop. In the absence of such descriptions, comma, the application appears to be bereft of the necessary details. Full stop. The comma and the aspects which have been highlighted by Mr. Das Lanet, Junior Government Advocate. Full stop. Mr. Das, Junior Government Advocate, Supreme Court, response number 2 and 3 has submitted that without the necessary details, comma, it is not possible to entertain the application. Full stop. He has, however, submitted that in the event the petitioner submits an application with proper description of the land parcels for mutation, comma, the application will be given due consideration. Full stop. In view of the above, comma, Mr. Chaudhary Learned Counsel for the petitioner has submitted that the petitioner will approach the respondent authorities, more particularly, comma, the respondent number
2 and 3.
1 or 2?
2 and 3, madam.
2 and 3 with a fresh application enclosing the necessary documents regarding the parcels of land in respect of which the petitioner is seeking mutation within a period of 15 days from today. Full stop. In view of such submission, comma, it is observed that in the event the petitioner submits a fresh application along with the necessary details and documents regarding his claim for mutation of the parcels of land, comma, within a period of 15 days, the respondent authorities, more particularly the respondent number 2 and 3, shall give due consideration to such application as expeditiously as possible, comma, preferably within a period of 1 month from the date of receipt of such application.
Regarding
And the full stop. The respondent authorities thereafter shall pass, shall intimate, inform the decision to the petitioner thereafter forthwith.
regarding Aadhaar card, any observation, maybe regarding Aadhaar card and
Give the consideration, they have to give a decision. They still insist for Aadhaar card will decide.
If they fail, then we can.
Supplementary list, item 58.
Please, your lordship. Lordship may take this matter after some time, lordship. Air Bhaiya is on.
Item 59.
Please, your lordship, I filed the additional affidavit,
Ah,
bringing on record the Cheetah.
let me go through it. Where is your name?
The application.
No, Dokaldar.
I have filed an additional affidavit to them.
Okay, next page. Okay, dock holder. Government khas land. Government khas land.
Yes, ma'am. Eviction notice was issued only in respect of Doug number 4 million.
Hmm?
I am in possession in 2 ducks. Eviction notice was issued only on the Doug number 4 million.
2, 4, and 5.
But I am in possession of 4.
Mr. Das, in page 19 of the petition.
19, my lord.
Huh? At least there is an application.
My lord, page 20 for time being, my lord.
Huh?
Page 20, my lord.
Page 20.
Yes, my lord.
Come to the particular one. 21.
You are required to vacate the land from the date of issuance of the notice till 1/11/2025. It's been already been over, my lord, 1/11.
Yeah.
Moreover, if you are not, if you are not vacate the land willingly, we will be evicted as per rule 18(2) of the Assam Land and Revenue. My lord, procedure will follow.
No, they are in possession still.
Yes, yes. Possession, my lord.
Rule
Procedure will
18(2)
follow, my lord.
requires a notice.
Yes. Hearing, my lord, hearing will take place.
My protection, my possession will be protected.
এইটো কি নাম আছে?
Sara Kudula. Like yes, Sara. Salakuddin.
Salakuddin procedure will be followed.
Yes. Yes, yes.
I may be, some protection may be given.
No, that is what.
It's clearly written in the notice itself, my lord.
Notice 18(2). 18(2) will be followed. If 18(2) is required to be followed, then
Sixty-four.
para 46 also.
Yes, my lord. 64 also.
Para 46. Because there appears to be an application for allotment.
Yes, para 46 also will come, my lord.
And what do you say?
64, my lord.
Heard Miss S. Roy. Learned counsel for the petitioners. And Ms. G. Hajorika. Learned standing counsel, Revenue Department for the response number 1. And Mr. Ann Das, learned Junior Government Advocate Assam for the response number
2, 3,
2,
4.
3, and 4. Post of. In view of the nature of issue raised and as agreed to by learned counsel for the parties, this petition is taken up for disposal at a motion stage itself. Post of. Para. The two petitioners have claimed that they are in possession of a parcel of land measuring 1 katha 1 lessa, covered by DAG number 4/4 and DAG number 9/9, situate at Dhuburi town, Khas Mahal, for the last 15 to 20 years. And their names are recorded in the Chita
as dockholders. Full stop. In support of their such claim, the petitioners have annexed a copy of the Chita, concerned Chita for dock number 4/4 as annexer Roman 6 to the writ petition. Full stop. The petitioners have further stated that they, as landless persons, applied before the respond number 2 in the year 2021 for allotment stroke grant of patta in respect of the parcels of land they are in occupation. Full stop. The petitioners have admitted that the parcels of land they are in occupation are government khas land. Full stop. The cause of action for the petitioners to approach this court by the present writ petition is issuance of a notice dated 24/10/2025 by the respondent number 4. Full stop. By the notice dated 24/10/2025, comma, the notices, including the petitioner, including the two petitioners, Ajiju and where is Sahinur? Okay, two petitioners have been informed that they are in unauthorized occupation of
Tag number 4.
dock number 4 of Dhubri town Khas Mahal, and therefore they should vacate the same within 1/11/2025 on their own. Full stop. The notice has further mentioned that in the event the notices do not vacate their land on their own, comma, actions will be taken under the provision of Rule 18 within bracket 2 of the Assam Land and Revenue Regulation 1886. Full stop. Mr. Das, Learned Counsel for the Learned Junior Government Advocate, preparing for the respondent number 224, has submitted that the notices by the notice dated 24/10/2025, including the two petitioners, were asked to vacate their land, vacate the parcels of land under their unauthorized occupation. Parcels of land covered by dock number 4 from the unauthorized occupation within 1/11/2025. Full stop. Or else, command procedure contemplated in section 80, Rule 18(2) of the 18(2) of the settlement rules framed under the Assam Land and Revenue Regulations 1886 would be followed. Full stop. He has submitted that it is implicit in Rule 18(2)
that proper opportunity of being heard would be afforded to the noticee
Notice.
prior to any action for eviction, as has been settled by this court in the decision in Salakuddin versus State of Assam and others, 2024 4 GLT 857. Full stop. Para. It is settled in
64.
It is a settled proposition that the wasteland stroke government khasland stroke estate over which no person had acquired the rights of a proprietor, landholder or settlement holder, an indigenous person who is in occupation of such lands under the disposal of the government would have a procedural legitimate expectation that before taking any decision to evict him, he will be given an opportunity to explain that he had a right to be considered for settlement over the land in his occupation. Full stop. Such right is, however, subject to a caveat that the occupier stroke possessor submits application for settlement and the settlement rules and the land policy permits such consideration for settlement. Full stop. The said person would also have a substantive legitimate expectation that he ought to be considered for settlement over the land in his possession in view of the Land Policy 2019, which is again subject to filing an application for settlement, and the Land Policy 2019 duly permitting consideration of such application for settlement. Full stop. The court in Salakuddin Supra has further observed that the state may have a more profound reason for eviction in respect of the land in possession on public interests. Full stop. Para. The petitioners have averred that they have already submitted an application for settlement of the parcel of land which are under their settlement of the government wasteland, which are under their occupation, and the same have not yet been given due consideration in spite of the communications made from the Revenue and Disaster Management Department, Service and Settlement Branch, Government of Assam, via communication bearing number, page 17, dated 29/7/2025. Full stop. By the communication dated by an communication bearing number, page 19, dated 15/10/2025, from the office of the District Commissioner Dhubri, within bracket the response number 2. The response number 3 had asked the response number 4 to look into the matter and facilitate the application of the application mentioned therein for allotment stroke settlement of land at Dhubri Town, Khas Mahal. Full stop. As the petitioners have claim that they have already submitted their application for allotment stroke settlement of the parcels of lands which are in their occupation, so of the government trust land, comma, the petitioner or shall respond to the notice dated 24/10/2025 by submitting their individual representations along with the supporting documents, along with the documents in support of their claim for such allotment stroke settlement before the respond number 4 within a period of 15 days from today.
7 days, man.
15 days.
7 days is enough.
Full stop. On a receipt of such representation, comma, before respond number 2 or respond number 4. On receipt of such representations, comma, respond number 2 or any other authority duly empowered under Rule 3 of the settlement rules shall give due consideration to such representations for arriving at a subjective satisfaction that there is there is either a bona fide claim of right involved or otherwise. Full stop. After giving consideration to the representations, the application for allotment stroke settlement and the land policy 2019. The respondent authorities shall only after shall give shall undertake proceedings under Rule 18(2) of the settlement rules. Full stop. So first you give consideration,
Yes,
thereafter you'll proceed under 18(2).
yes.
Till the decision of the respondent, but I may be protected.
Till the decision is rendered on the representations, comma, no coercive action against the petition shall be undertaken. Disorder disposal of the reputation. Yes, anything to be done?
Yes, man.
You dispose of.
Yes.
Item 16.
May it please the court.
What documents?
Well, the petitioner has challenged the election of the respondent number 7 as the member of an Anchalik Panchayat and pursuant thereto as the president of the Anchalik Panchayat, my lords. Well, the petitioner contends, my lords,
What new document? Counterfeit.
counterfeit, my lords.
Where is he?
My lord, my first,
Okay, we have to issue notice at this stage.
my lords, if I may kindly point out, my lords, just for a moment, my lords. Lordship may kindly come to page 45 for a moment, the affidavit submitted by him before the election authorities, my lord, page 45. My lord, page 46 is the relevant portion. Paragraph 3, my lord. May I read, my lord? That
It
the
is passed.
educational qualification which I submitted at the time of filing application ensuing panchayat election is my highest maximum educational qualification, that is HS pass in the year 2020, being roll number 0919, number 20111. And if any discrepancies arise regarding my highest maximum educational qualification, that is HS pass, passed in future, then I shall be liable to be terminated from the panchayat election. Now, the documents submitted by him, my lords would find in the subsequent pages, my lord. Page 47 is the pass certificate bearing the same roll number, and page 48 is the mark sheet. May Lordship may kindly come to page 48, my lords. The same roll number, which is there in the affidavit, my lords.
Where is the roll number?
Roll number is 0919.
Which part?
My lords, below, my lords.
Hmm?
0919 and 20111.
Page 48.
Page 48, my lords. It's a mark sheet, my lords, issued by the Assam Higher Secondary Council.
Okay.
So it bears the same roll number, my lords,
Hmm.
and it says, my lord, second division. If my lord observes at the bottom, second division.
Hmm.
Now, my lords, RTI application was made, my lords, with regard to the same roll number and the mark sheet, my lords, before the council. Now the council is renamed as, my lord, Assam State School Education Board, my lord. Before it was the council, my lords. The reply, my lord, would find at page 49. Name Mamun Shah. Number 2, result, repeat. And my lords, if my lord turns the page, my lords, at page 50.
Hmm.
If my lord turns the page kindly, my lords, page 50, the mark sheet submitted by him, my lords, the council, by way of seal and signature, had marked it as counterfeit, my lords.
Ah.
And next page again, my lords, the pass certificate also counterfeit, my lords. Now, my lords, I have filed an additional affidavit today, my lords.
Hmm.
That was brought on record, my lord. There's another RTI application which was filed with regard to the declaration made by the respondent number 7. Now, again, the same reply, my lords. The reply is from the authority itself, my lords, the council. This is the original copy, if my lord wishes to tell you, my lords. Original seal and stamp, my lords, by the council.
Okay. Okay.
And the section is very clear, my lords. The member shall not remain as a member if he is disqualified. So,
That I know.
yes.
That I know, sir.
I'm just praying for
Knowing fully well, I have said.
Yes. This is the original, my lord.
At least everybody has an opportunity, but no major decision, mister.
No major decision. Yes.
No major financial decision.
I'm
That I
obliged.
know.
I'm obliged. I'm very grateful, my lord.
I heard Mr. P. Mohanto. Yes, where is the standing council, Panchayat? Huh? For whom? You are standing, huh? What do you have to say?
Notice may be issued.
Hmm?
Notice may be issued.
From Panchayat. Which is the specific rule?
11 2C, my lords. 111 2C. It's been inserted pursuant to the 2018 amendment, my lords. 2C. 111 2C.
And he became president or what?
Yes. First, he was a member, then he became a president by
Okay.
resolution dated.
Miss.
P. Thapa.
But Mr. Sharma, you are the authority, I think. Miss.
With representations also.
P. Thapa, Lord.
B. Thapa.
P. Thapa.
B. Thapa. Learned Council representing Mr. S. Dr. Alliance Standing Council, Panchayat and Rural Development Department for the response number 134.
And 4.
Mr. H. Sharma, Learned Additional Senior Government Advocate Assam for the response number 2. And Mr. P.B. Castro, Learned Council representing Mr. R. Dubey, Learned Standing Council, Assam State Election Commission for the response number 6. Any is okay. Full stop. The petitioner as well as the respondent number 7 and as well as the respondent number 7 were among the candidates who submitted nomination papers to contest the election for
Number two,
member from number one, from a member to the number two Phekamari Ancholik Panchayat in the Panchayat general election held recently, post of. The respondent number 7 was declared elected. Full stop. Para. The petitioner's contention is that section 111 within bracket 2 within bracket small c has inter alia prescribed that for being elected as a president, comma, vice president, or a member of elected, or to remain as a president, vice president, or a member of an Anchalik Panchayat, comma, a person shall possess a minimum qualification of HSSLC or equivalent examination under any council or board recognized by the state or the central government, full stop. Along with the nomination, comma, the respondent number 7 had sworn in the affidavit cum declaration that he passed higher secondary examination in the year 2020 with roll number 0919, number 20111, full stop. But as per the information provided by the Assam State School Selection Board, comma, Guwahati, comma, which is earlier known as the Assam Higher Secondary Education Council, comma, Assam. The candidate bearing roll number 0919, number 20111 by the name of quote unquote Mamun, MAMUN Shah, was not successful, meaning thereby, comma, the respondent number 7 does not have the prescribed as HSSLC or equivalent examination qualification to remain either as a member of the Anchalik Panchayat, either as a member or as a president of the Anchalik Panchayat. Full stop. The petitioner has stated that in the first meeting of the Anchalik Panchayat, comma, the petition, respondent number 7 has also been elected as the president of the Anchalik.
first meeting I was elected, he challenged it. Yes, what-
As on date, the petitioner is discharged in his function as a president of the now
The respondent is-
number 2, respondent number 7
Right.
is functioning as president of number 2 Phekamari Anchalik Panchayat Post. Para issue notice returnable so and so as so and so has appeared accepted. No formal notice, huh? Extra copies during 2 working days. The petitioner shall take steps for service of notice upon the respondent number 5 and the respondent number 7 by speed post within 2 working days from today. Post. Hurdle and council for the party is also on the interim prayer. Post. The petitioner has relied upon documents information provided by the Assam State School Education Board, Guwahati, which are annexed as Annex 1 to the additional affidavit as well as Annex
F.
F. Poly to the repetition. From the said documents, it primarily transpires that the respondent number 7 does not have the qualification as prescribed in section 111 2C of the Assam Panchayat Act. Wait, go to Assam Panchayat. In such view of the matter, it is ordered in the interim that the respondent number 7 shall not take any financial decision in respect of the affairs of number so and so, Pekamari Anchalik Panchayat, till the returnable date, post stop, on the returnable date, the prayer for further the prayer for further interim relief is kept open for consideration on the returnable date.
DP of December. DP. Take back your original.
Yes.
Lordship, the pendency shall not be a bar in disposing of this complaint petition which he has submitted. by
It is
giving-
further observed that as the petitioner has already submitted a representation before whom?
Before the deputy commissioner, Lord.
Before the deputy
Where is
commissioner.
that? Where is that?
District commissioner, at page 55.
Before the respondent number 2, already on 30/10/2025.
As from this document, it reflects that list of enclosures, Lordship, the school board verification or RTI replies, most probably they have annexed all these things there.
If it
So by giving an opportunity,
Uh,
Lordship, it can be
uh,
disposed.
It is open for the respondent number 2 to proceed with an inquiry and to take appropriate decision in as per the procedure prescribed in the Assam Panchayat
Gotcha.
Act. It's 2000 as amended, 1994 as amended.
DP of Blackman.
Item 61.
Yes, it will take some time.
My understanding is that this petition has become infractions. They have missed the bus, madam. They have already been evicted, madam.
No, my lord.
Specific written instruction. I have.
So
So let notice go, madam.
my lord,
Then notice will go.
my lord, we have challenged the notification of 73.
Status quo as on obtaining today, then you will not be able to come back.
My lord.
Status quo is my power, madam.
Notice may go.
Uh-huh.
Notice may go, my
Let
lord.
notice go, madam. Because my specific written instruction is that they have been evicted.
Yes, we have been evicted, but
Exactly.
how evicted, my lord, that is to be looked in.
That can be undone at the final hearing stage, madam.
And we have, our challenge is basically, my lord, the application of notification 5/4/1973.
We can deliver it on it
After
then.
52 years.
We can deliver it on it. Heard Mr. A.R. Sikdar, learned counsel for the petitions. And Mr. P.N. Goswami, learned additional advocate general. Some listed by Ms. M. Polita, learned counsel for all the.
Except 3, madam.
Okay, for respondent number 1, 2. Then
4, 5,
to 7.
6, 7, madam.
4 to 7. And Ms. P.R. Mohanto, learned standing counsel, Revenue Department for the respondent number 3. Goes from. The petitioners have essayed the impugn actions undertaken by the respondent authorities in evicting. Undertaken by the respondent authorities for their eviction
Dohikota Reserve Forest.
from areas within the Dohikota Reserve Forest. Post of it is the contention of the petitioner that you are outside.
Outside, my lord, how we are evicted, my lord, that.
Oh, no, your claim is what? You are
My
outside
claim is
Dohikota
that
Reserve Forest.
my village is not in the
Okay.
forest.
The contention of the petitioner.
And
is that
this no division is not
areas
being
of
applied.
land- Areas of land, the petitioners were in occupation, are outside,
First land, my
outside the declared boundaries of the Dohikota Reserve Forest.
lord, we are in khas
Post
land,
of-
my lord.
According to the petitioners, they are in occupation, they were in occupation of government khas lands. And as such, the forest department authorities do not have the authority and jurisdiction to evict them. Post of Mr. Sigdar has submitted that in the meantime, pursuant to the notice dated 7/10/2025, the petitioners have been forcefully evicted from the parcels of land they were in occupation. Post of Mr. Goswami, learned additional advocate general, has also submitted an instruction that the petitioners have already been evicted pursuant to the notice dated 7/10/2025
Only
by following due procedure.
after issuing speaking order to them, madam.
And after
We
issuance
have
of
not received any speaking order, my lord.
speaking order on the basis of their representation. Submissions, sir. Submissions.
Right now I'm handing over all the speaking order.
Full stop. He has further submitted that all the petitioners were found to be occupiers of parcels of land inside the declared boundaries of Dohikota Reserve Forest. Post of the matter would require consideration, issue notice returnable on so-and-so date as Mr. So-and-so, and Ms. Kolita has appeared and accepted, and Monto has appeared and accepted. No formal notice, extra copies within 3 working days.
Obliged.
12th December, 12th.
Yeah, I'm making a mention at this odd hour, my lord. That's item number 47, my lord. In this case, I have lost contact with the client, and secondly, my lord, this is against state government. Now I think I cannot appear, my lord, in principle, my lord. So, my lord, I need some time to take instruction, my lord, because I have lost contact with the client also, my lord.
You informed the other side.
I am for the
Other side.
applicant in the IL. I am the applicant in the IL. And
You are for the petitioner?
I am for the petitioner.
Okay. Mr. R. Kosik, Learning Council. Has submitted that he has lost contact with the client. Therefore, the matter be posted after 2 weeks
2 weeks, my lord.
in order to obtain instructions in a matter. First, Mr. Anjay Gugoi, Learned Standing Council, ASAMB, who is present, has submitted that he has no objection to appear. This is the case accordingly after 2 weeks.
Obliged, my lord.
Item 62.
Dohikota.
May I please, your lordship? My lord, matter regarding my lord eviction from his own house, my lord. My lord,
Retired person residing in own house on the municipal board. Patta land.
yes, my lord, fatal and my lord. I describe everything in my petition, my lord.
No, which is no circle office.
For widening of the road, my lord, they wanted to, they put a mark 4 feet inside
Where
my
is the gazette
boundary,
notification?
my lord.
What is the gazette notification?
Gazette notification.
Oh, direct
yeah,
purchase.
Yeah, yes, my
Direct
lord.
purchase.
Direct purchase. Nothing, my lord, they have not followed any procedure of law, my lord. Straightway, when they take measurement,
Where is your letter? 17.5.
yes, my lord, page 35, my lord.
35.
Translated copy, my lord. 37, my lord. Particular.
Page 30?
37, my lord, particular, my lord.
That is your letter.
Yes, my lord.
No, what is there any correspondence with you? By the Deputy
No
Commissioner?
correspondence, my lord. We submitted representation before the Deputy Commissioner, my lord. And Deputy Commissioner, my lord, at page 39, my lord, forwarded the matter before the circle
Yes,
officer.
Mr.
But circle
Sharma,
officer,
I have to give the instructions.
please find out.
on 17/5/2025, my lord, Deputy Commissioner forwarded the matter before the circle officer, Daboka Revenue Circle, but till date, my lord, they have not hearing me and also.
At what time you can take instruction?
Lordship,
At what time? By what time?
next week, Lordship, any date as per Lordship's condition.
Let him take instruction.
Lordship,
My lord, in the meantime, my lord,
Lordship, as because it's
they
a
are approached.
development work of the.
Did you enter into any agreement?
Yes. My lord,
Did you enter into any agreement?
no,
Huh?
no. No,
Whether,
no, my lord.
If it is not, then cannot take.
no, Lordship, even that,
Agreement, they have not approached me also.
Find out at the earliest.
Lordship,
Next Monday?
Lordship.
Heard Mr. A.J. Atiyal and counsel for the petitioner. And
As because
A for
it's a-
Saiji. Oh.
Two.
Here for whom? Two.
Yes.
Revenue. Two. Miss H. Borua, standing also PWD. 1. H. Sharma.
346.
346. H. Borua 1 and 5. Also, the petition claims that he is he is the owner of a periodic patta land covered by DAG number 961 and 962 and patta number 573 and 574, situated at Doboka Town, Kisam,
Ward number 7.
Ward number 7, Doboka, and within the areas of Doboka Municipality, District Ojai. Post op. The petitioner has alleged that on the pretext of construction of Doboka Jamunamuk Road, the respondent authorities had marked in an area up to 4 feet inside the petitioner's
Dwelling house.
patta land. In the pretext of widening of the, without following any due procedure of law. Post op. The petitioner is under apprehension that at any time, the respondent authorities may take over the extent of land up to the marked portion. Post op. Para Mr. Sharma, learned additional senior government advocate has submitted that he will obtain instruction in the matter. As the petitioner has already submitted a representative petition, which is under consideration of the respondent number,
That's respond number, my lord.
circle officer 6.
Circle officer, my lord, 6.
Post op. As sought for is the case on when? Next Wednesday?
Lordship, that will be better, Lordship.
Amen.
Nineteen.
99, I will not be available.
21 or 17,
17 may be a little bit early, Lordship. because
21, 11, 2025
25.
to enable Mr. Sharma to obtain the necessary instructions. Post in the meantime, comma, the respondent authority shall not take over any area within the Patta land without due procedure of law.
My lord, some correction is there, my lord. Some, allow me to rectify, some correction is. in the
Which
prayer-
one?
Prayer portion, my lord, wrongly inserted, wrong number, my lord.
Copy
Page
paste.
number 15, my lord, it should be, my lord, 962, Doug number. And the old Doug number is. Yeah. Page number 15, my lord. In the prayer portion, my lord, initially I
A
inserted-
whole lot correction.
No, my lord, only
What? Every Doug number, every Patta number.
two Doug number, two Patta number. my lord. My
Four.
lord, in the initial prayer portion, initially I put my lord, a correct number, my lord. At page 14, my lord. Page 14.
The petitioner is, learned counsel for the petitioner is allowed to, as Mr. Mr. Atia submitted that some inadvertent mistakes have crept in the intent prayer portion of the petition. And the same is required to be in conformity with the main prayer in the petition. So he has thus submitted for a leave to correct the same. So the learned counsel for the petitioner is corrected, is allowed to make the corrections in his own hand before the registrar judiciary.
Item 63.
May I get the extra copy, Lordship, from my lord?
Extra copy. The counsel for the petitions are furnished an extra copy of the petition along with annexure to Mr. Sharma. Today only,
Lords.
during the course of the day. Yes.
May I please, your lord? My lord, basically we are challenging some eviction notices, my lord, which has been issued. My lord, we are a long-standing resident of the particular area, my lord, and my lord may be pleased to find the notices starts from page 170, annexure 9.
Yes, in what manner?
Yes, my lord, the manner in this, my lord, if we, my lord, go by the notice, my lord, there is no mention has been made that how much land I have occupied. Or, my lord, what is the area or the Doug number, nothing has been incorporated, only saying that we have occupied some land and destroyed the forest properties, my lord. And that in view of the, my lord, two judgment passed by our honorable High Court, my lord, in PIL and as well as the reference has also been made in respect of two writ appeal numbers, my lord. And therefore, they have given 15 days time to initiate the notices. Now, my lord, herein is a case wherein, my lord, we are residing. Some of the areas, my lord, fall within the revenue and some of the areas fall within the, my lord, no doubt. My lord, there are some reserve forests are there. Now, my lord, though the reserve forests are there, my lord, we have been treated under the, my lord, reserve forest, the benefit of the panchayats and other, my lord, beneficial legislation which has been made for the purpose of extending under the Food Security Act had also been provided, treating us as a genuine citizen of that particular forest area, my lord. Now, my lord, the my lord, submission is coming, my lord, from the forest department that once this area has been notified as a forest, my lord, so therefore, there cannot be any question of, my lord, that the Panchayat Act or other benefit, even if it is given, my lord, that will override the, my lord, the under the, my lord, law of the Forest Conservation Act of 1980 and other laws made in the parliament, my lord. So therefore, my lord, with all respect, my lord, my respectful submission before my lord is there. My lord, this reference of the writ appeal number 251/252, my lord, is a subject matter, my lord, which this order has been assailed before the Honorable Apex Court, my lord, exactly for the similar sort of, my lord, forest, my lord, villages. And now the Honorable Apex Court, my lord, has directed that till the issue is decided, my lord, to maintain the status quo amongst the parties, my lord. So, my lord, as the reference has been here is also been made, my lord. So therefore, my lord, may I pray, my lord, that that matter is fixed on 14th of this, my lord, month for hearing, my lord, before the Honorable Apex Court, my lord. That Honorable Apex Court order, my lord, I have annexed, my lord, in page number, my lord, 169, my lord.
Okay, this 251 and 252.
251 and 252, yes, my lord, it is connected, and that 251, 252 order, my lord, is at page 167, my lord. My lord, may kindly find in the heading, my lord, arising out of the impure
That I
file,
have seen.
my lord, my lord. So, my lord, may I humbly pray, my lord, till this issue is on 14th, it is fixed for final hearing. Lots of matter is when there, my lord, and all the matters had been clubbed therein, my lord. So, my lord, the issue which we have raised, my lord, in those special leave petition along with the other grounds, that under the Assam Panchayat Act, my lord, section 5, there is a provision, my lordship knows, my lord, there is a provision called, my lord, forest villages, my lord. So if within the forest area, some peoples or some residents are there, my lord, they are inducted as a forest, my lord, Panchayat area, and their name had also been incorporated in the voter list under the section 5 of the, my lord, Assam Panchayat Act of 1994, my lord. And by virtue of that incorporation, my lord, we have been extended with the benefit under this Panchayat and other legislation, my lord. So that issue, my lord, has been pending, that whether, my lord, in a forest area, section 5 can be applied or not, my lord. That is the issue, my lord. And in this petition, my lord, we have also raised,
What is this forest?
this is, my lord,
When it was notified?
notified, my lord, long back, my lord,
1918, my lord.
1980. Jamuna Modonga Reserve Forest, my lord. I know?
Yeah.
If we have annexed the voter lists also, my lord. So, my lord, as per the notice, one,
Otherwise, law is that
my lord,
anything acquired is null and void after 1918.
after 1980, my lord. That after the Forest Conservation Act came into force.
Plethora, not. It is Assam Forest Regulation.
My lord, my lord, my lord. No, my lord, what?
Forest conservation much later. 1980 Act.
1980 Act, my lord, correct. No, prior to that, there
This
is
is
law, my lord.
Assam Forest Regulation is
1891, my lord.
provisions is are perimeter with Indian Forest Act, 1928,
27, my lord.
27. And plethora of decisions. No, nothing can be acquired after 1980.
But, my lord, that I have also, my lord, gone through that.
But
if,
I think Assam Forest, Assam Forest Regulation and Indian Forest Act that have not been discussed, I think.
in this
In the-
petition, in this petition.
No, in the 251 also.
No, that
252.
has not been discussed, my lord. That has been, my lord, but a sale in the SLP, my lord, sale in the SLP.
Yes, what do you say? 14 is the
My lord,
date.
I
If that is the
strongly,
date-
I strongly disagree, my lord. That way, my lord, entire proceedings before your lordship will get diverted, my lord. Because this was a plea taken by them earlier also, that there is a status quo order passed by Honorable Supreme Court in 251 of 2021, 25 writ appeal. Despite that, my lord, orders were issued. There are consistent orders from this court that the petitioner will go and file the representation, will make a joint verification with the revenue authorities, will pass a speaking order, then only will proceed against eviction.
We have found instances
So,
in
my lord,
other cases, many
If we, my lord,
many petitioners have been exempted.
if my lord now perishes, my lord, that Supreme Court order against 251 writ appeal, page 167.
No, I have brought in.
167.
167, my lord, perishes, my lord. Yes. Last para, my lord, pending disposal of the special leave petition, the parties shall maintain status quo. It's not a stay order of a judgment of the Honorable High Court, my lord, division bench. It is about among the parties therein, my lord. So it is confined to those parties, my lord. They have got that status quo order. So it has nothing to do with, my lord, the main order. So in fact, my lord, after this, there was a PIL file, my lord, wherein my learned friend was there, my lord, which was placed before that. This Honorable Supreme Court order was passed, my lord. It was dated, my lord, will see 22/8/2025. Honorable Supreme Court, sir. There are hundreds of orders thereafter, my lords have passed. This Honorable Court has passed. Division bench has passed to proceed in accordance with the guidelines prescribed by Writ Appeal 251. In fact, my lord, in the meantime, my lord, my learned friend moved a PIL 39 of 2025, which was dismissed, my lord, and it was clearly discussed, my lord. It was clearly discussed. My lord has already seen, my lord, date is 22/8/2025, Supreme Court's order. This order, my lord, will see at page 23, my lord, of that bunch of documents. It starts at page 21. 23, my lord, will take note of the date, my lord, 10/9/2025. Then, my lord, paragraph 7, my lord, will kindly see at page 27. The learned Advocate General further submits that the Chief Minister of Assam has not so and so, so and so. The learned AG further submits that the concession given by him in the order that so and so would also be applicable in this case. This 251 was, my lord, taken note of, my lord, despite there was a status quo order. In fact, my lord, status quo order was placed before that court also, division bench. My lord, will see paragraph 12, my lord, page 28. This argument, my lord, was made on several occasions that we should wait for a Supreme Court's order, my lord. It was not accepted because it was only status quo order, not an absolute stay, my lord. Paragraph 12. The issue of eviction in the present case is with respect to encroachment and the unauthorized structures built within the reserve forest area. It has nothing to do with persons having any criminal case against them, be that as it may. In a similar case pertaining to the same reserve forest, a coordinated bench fight order dated 18/8/2025 disposed of Writ Appeal number so and so by holding that if a drive for clearing reserve forest areas of all encroachment was undertaken, and if it was found that there was some unauthorized settlers, they ought to have been given a reasonable time of 15 days to explain under what circumstances they had set up their residence inside the forest area where any non-forest activity or their presence attracted penal offense. They were then to be given a further period of 15 days thereafter for vacating the place if they were found to be as encroachers. Consistently, my lord, this order is being followed even by this division bench order, thereafter by your lordships, by all other single benches, my lord. Now it is too late in the day to make the same argument that there is a status quo order pending in case pending in Supreme Court where there is a status quo order. In every petition, my lord, they have annexed that. And if I may take your lordship to paragraph 6 of the writ petition, my lord finds at page 20. We all know, my lord, to have a title, he has to have a patta or a cell deed, my lord. Getting an electricity connection from APDCL will not make him a landlord, my lord. Landowner, sorry, my lord. Page 20, my lord. Paragraph 6. It is further submitted that such possession and occupation being lawful and recognized by the rightful pattadars, entitles the petitioners to protection under Article 21 of the Constitution of India, which guarantees the right to life and livelihood, including shelter. Any arbitrary eviction or demolition hearing or any due process without hearing or due process would amount to a direct violation of their fundamental and human rights, particularly when their residence on the land is not encroachment by trespass by a settled occupancy with the express approval of title holders. Petitioners are not the owners of the said lands and they do not have any ownership right. It is their own statement on oath.
Yes, my lord.
So where are the landlords, my lord? He is occupying a patta land of somebody else. The landlord should have come, my lord. Landowner.
Mr. Bhuya, para 2.
My lord.
With due knowledge, permission and authority of the original landowners.
Exactly. Where are they?
If you are occupancy tenants
No, my lord.
or even sub-occupancy tenants,
Lord, what has happened?
your claim is against the original landowner.
No, that is what has happened, but they have issued the notices to us, my lord.
Because they are not holding any revenue land, my lord.
Tell me, who are the original pattadas?
My lord, those persons, my lord.
Where is your Dagan patta?
Nothing, my lord.
No. My lord, we are not saying that these are patta land or something like that, my lord. We are
No,
the original people, my lord, who
No,
were
original,
here.
no.
My lord.
That's, I am asking.
My lord.
Para 2,
My lord.
you have said that due knowledge,
permission and authority of the original landowners.
My lord, my lord.
You are saying so.
Yes, yes, my lord. It's
So
my
who are the landowners?
My lord, that is the persons, my lord, who were original inhabitant and later on, my
Hmm?
lord, handed over to
No,
us.
there, landowner
Only-
definition is clear.
My lord, with all respect. my lord.
Landholder,
No, no, my lord, even my case is being not entertained by my lordship, so.
no, no, I am not
I-
into that.
My lord, I am not submitting any false statement, my lord. This, we do not have any right title in our name, my lord. It is admitted.
No, but
We-
if
my lord,
if you are suppose
My lord,
holding the land
my lord.
with the knowledge of
Those.
original landowner,
Yes, yes, my lord.
there has to be a landowner,
Yes, yes, some,
Either-
some authority, some.
either entity, a person,
My lord,
living person or dead person,
my lord.
right?
My lord, that is correct, my lord.
All right, then that person might have the patta
My lord.
or title. Then you can claim through him.
Yes, yes,
Right.
yes.
So
I mean, Lord,
have you disclosed those?
Yes, yes.
Because
It is required. it is
while
required.
because the arrow which is meant for Sugriv is also meant for Bali,
My lord,
right?
my lord.
So you are claiming that they are not disclosing
Correct.
the land details.
We need to.
You are also not disclosing your land details.
We are required to make a table, my lord. Who are the original landholder against these petitioners?
And there is nothing
My lord, that is.
as
correct.
on date.
That is
So only option is that you respond to that.
Yes, yes.
You have the opportunity
My
to
lord,
respond with all the details.
my lord, we'll try.
Otherwise, that has been the consistently
My lord,
followed.
I'll try, my lord.
My lord, best course of action, if I may suggest, my lord, would be to pass those order, my lord, wherein they will respond to the notices, my lord, in terms of readable my order, my lord.
Yes.
In fact, it is the pleaded case, my lord. Paragraph 12, my lord.
It is not that they are, I don't know, maybe correct or may not be correct. But in some cases,
My-
today I also have come across
My lord.
that few are exempted.
Yes, we have excluded those
They have
who are having
found
patta.
their lands outside
No, no,
the
my lord.
reserve forest
My
area.
lord, my learned friend's department is very fair, my lord. Is
And they
very
have
fair.
carried out
Those even-
joint verification process with the revenue authorities.
My lord.
Thereafter, few of the notices,
My lord.
land were found outside the reserve area, they have been exempted. In our case also, today,
No.
one has been found inside, one has been found outside.
But my lord, something is very disturbing is that, my lord, the manner in which this eviction is carried out is also being classified, my lord. That classification is very dangerous, my lord. It's unconstitutional, my lord.
Which classified, that has been
My lord,
discussed in this judgment.
that is correct, my lord. That is correct, my lord. Now, my lord, may I pray? my
So
lord?
that will be again,
My-
Article 14, there are two shades to it.
My lord,
One is positive, one is negative.
my lord.
There
My
are
lord,
two
my
shades to it.
My lord, recently I have visited the Katabari area, my lord, wherein, my lord, our few colleagues are also there, my lord. So the manner in which the notices were issued is very disturbing, my lord. Because my neighbors, my lord, I should not utter these words before this forum, my lord. I think my lordship can understand, my lord. So this is the policy the present government is adopting, my lord. Very disturbing, my lord. My lord, my lord, one thing, one more submission I beg to make, my lord. My lordship knows, my lord, that before the eviction or any, my lord, resettlement, my lord, there is a judgment of the Honorable Apex Court from Olga Tellis to Ajay Makan, that first government should come up with a policy.
LEC with footpath,
It's
No,
not, it has nothing to do with forest.
pedestrians.
But my lord, but
No, pedestrians and invasion of forest
Municipal-
area is
municipal
not
areas
very
discussion.
comparable.
my lord. But even then, my lord, that principle and analogy, because the human rights is there, my lord.
No,
Because,
this
my lord.
particular notice,
my lord.
here it is clear that আপোনাৰ দখলৰ ন্যায্যতা প্ৰদান কৰিবলৈ
হয়।
যিকোনো দাবী প্ৰতিনিধিত্ব সমৰ্থনকাৰী নথি পত্ৰ যদি আছে দাখিল কৰিবলৈ জনোৱা হ'ল।
Yes, my lord.
Good enough.
Paragraph 13 for a moment, his own statement, my lord. Page 20, page 30, my lord. Page 30, my lord.
30.
30, my lord. Paragraph 13. That the petitioners most respectfully submit that the present case arises out of similar circumstances as other eviction matters from Nagaon district where residents have been served eviction notices by the forest department claiming the land to be part of the Bodapani reserve. It's a different forest, my lord. It is submitted that earlier certain similar situated persons from the same locality had approached Honorable High Court by filing so and so, apprehending eviction before the issuance of any formal eviction notice. The said writ petition is still pending consideration before Honorable Court. Subsequently, after the filing of WPC so and so, the said petitioners were served with individual eviction notices. And therefore, they again approached this Honorable Court by filing so and so, which has since been disposed of. In that case, the Honorable Court was pleased to direct that no eviction process shall be carried out without following the due procedure prescribed by law, and further directed the Forest Department and the concerned revenue authorities under the District Commissioner Nagaon to conduct a joint verification of the land in question to ascertain whether it falls within a reserve forest or a revenue village before taking any further steps. That in view of the aforesaid directions and considering that the present petitioners are residents of the same district and are similarly situated, it is humbly submitted that they are entitled to similar protection and equal treatment in parity with the petitioners in the aforesaid matters. Accordingly, it is most humbly prayed that this Honorable Court may please to direct that no eviction coercive action shall be taken against the petitioner without proper verification of land status. So they now have to only to react to the notices, my lord. That will, my lord, be in tune with the direction of the division bench, in tune with earlier directions of your lordships. And if they again remain aggrieved, I have seen, my lord, thereafter also people have come after the speaking orders were passed. Today, that matter, my lord, we have again gone for a specific verification to that particular 3 petitioners. I think, my lord, that will suffice, my lord. This petition can be disposed of in that direction.
My lord. My lord, I have
You also in your representation submit the details of the land.
responding to the notice.
In respect of which you are in occupation.
140.
And if it is revenue land,
My lord. They will make a joint verification.
it falls under revenue village.
There is a direction
Definitely.
passed by your lordship in our earlier proceeding, my lord. DSN.
I have annexed an order, my lord, exactly in the similar line, my lord, at page
Yes.
152.
Just
my
a
lord.
minute.
Page 146 is your lordship's order. Sorry.
Just a minute. Doctor.
Verification process.
Just a minute.
46 is an order passed by your lordship in connection with a Dohikata reserve forest of wherein, my lord, for the first time, my lord, allowed them to file representation. Preceding facts would be different, but the operative part, my lord. Hmm? 156 আছে মোৰটো নালাগে ডিক্সিটো বেটাৰৰ কাৰণে 156 Okay.
Yes, Mr. Bhuya.
My lord, my lord, my lord, if they are going to make a demarcation, my lord, by the joint verification, my lord, then it will resolve the entire issue. And till the, my lord, only my lord,
It is there
my lord, till,
that
because nowadays, my
My lord directs us to go for a joint verification, my lord. There cannot be any question of evicting them before that, my lord.
no, my lord, I am
Pass a
not,
speaking order.
my lord, I fully believe on my learned senior friend submission, my lord, and it is not happening till date in any case, my lord. But, my lord, the authorities, my lord, sometime, my lord, in a very rash manner, come up with bulldozers, my lord, and bulldoze. That apprehension is always there, my lord.
Art. Mr. A.R. Bhuya,
Thank you.
learned counsel for the petitioners.
That is Gupta asking, reserve for fun. Lutu, my.
And Mr. P.N. Goswami, learned traditional advocate general estate by Mr. I. Kolita, learned counsel for the respondent number
2, 3, my lord.
2, 3,
5, 6, 7, 8, 9, 10. 5 to 15, my lord.
5 to 15. Ms. P.R. Mohanto, learned standing counsel, revenue department for the respondent number 4. full stop. The petitioners, 63 number, I have joined together to institute the present writ petition under Article 226 of the Constitution of India to assail a set of notices issued to them comma, on, all dates same?
My lord, 10-10 and 8-10, my lord.
Okay. On 8-10-2025 and 10-10-2025, comma, annexed to the, by the respondent, annexed to the expedition as annexer 9
My lord, no, my lord, annexure 9 Kohli series we have starts at page.
annexed as, annexed collectively as
Annexure 9. Kohli
annexer
series.
9,
My lord.
comma, by the respondent number,
By the divisional forest officer, my lord,
who
South
is
Nagaon.
the respondent? By the divisional
DFO
forest officer,
Nagaon.
South Nagaon Forest Division, Hojai, within bracket, the respondent number.
6.
6 and 7, my lord. Two notices by two different authorities, my lord. 6 and 7,
Is it?
my lord.
Okay, divisional forest officer, South Nagaon Forest Division and the divisional forest within bracket respondent number 6 and the divisional forest officer, Nagaon Forest Division,
My-
Nagaon within bracket respondent number 7. Full stop. Para the common case of the petitioners, comma in brief is that they have been residing in villages
Mention.
that's Rongalu Bosti, comma Udmari, that's Pub Jamuna Gaon, comma Udmari, that's Posim Jamuna Gaon, comma Udmari Ruarpar, and Supurgaon, para 3 আছে. Within the districts of Hojai and Nagaon respectively, since last about 7 to 8 decades.
My-
Full stop. The petitioners have stated that they have all the relevant documents parceling to the parcels of land on which they are staying since long. Full stop. The petitioners have stated that they have been served with notices, comma, dated 8-10-2025 and 10-10-2025 by the respondent number 6 and the respondent number 7 respectively. And in those notices, comma, it is mentioned that the petitioners are in unauthorized occupation of lands falling within
My lord,
Jamuna
Maudonga.
Modonga Reserve Forest. And while in unauthorized occupation of the such reserve forest lands, comma, they have constructed houses, planted commercial vegetation, comma, dark ponds, comma, cut trees and plants, etc. inside the reserve forest areas and made conversion of the forest land for agricultural purposes. Also, the notice further mentioned that such activities are prohibited and illegal as per the provisions of section 24 and 25 of the Assam Forest Regulation 1891 as amended. Full stop. By the notice, comma, the petitioners have been asked to submit their claims to representations along with the supporting documents, comma, if any, comma, in justification of their possession of the parcels of land which the respondent authorities have claimed to be inside the declared boundaries of the Jamuna Modonga Reserve Forest. It is reserve or reserved?
Reserved,
Reserved. Reserve Forest.
My lord, there are two reserve forests for two
No,
different
no,
notices.
it is D, ends with D or without D?
সংরক্ষণ would have been reserved.
Reserved.
সংরক্ষিত is reserved.
Reserved.
So it is what?
Reserved.
Reserved.
It is.
Reserved.
My lord, there are two reserve forests. One is Jamuna Maudonga and one is Lutumai, my lord. Two notices.
Is it? Which?
Notices starts from, my lord, 8-10-2025 is in.
Where are those notices?
My lord,
8-10.
it starts at page, my lord, kindly find from page number 200 and 276.
10/10/2025 notice is my lord Jamuna Modonga. And 8/10 is my lord Lutumai.
Lutumai.
Lutumai এখন ক'ত আছে?
Actually,
Actually, my lord,
276.
this
Should not have been clapped.
my lord,
Lutumai reserve.
could not have been club. My lord. Two
Aye.
different forests, two
Mr.
different.
Bhuya has done it.
He has just now told me, my lord, that he is also tired of filing cases. That's why he has cut it short, my lord. It's okay, my lord. I don't object to that.
লিখিব নেক্সট আৰু এটা তাতে য'তে যমুনা মৌডুঙা আছে ন ৰিজাৰ্ভ ফৰেষ্ট তাৰ লগত আপুনি লিখিব লুটুমাই ৰিজাৰ্ভ ফৰেষ্ট হা
Lutumai.
লুটুমাই
Spelling to be Lutumai.
The petitioners have stated that they by no means can be termed as illegal encroachers of forest lands, as they have been living in the areas for the past 7 to 8 decades after constructing their dwelling houses and after obtaining electricity connection and securing voting rights. Full stop. In support of their such claim, they have annexed a voter list where our names are enrolled. Full stop. It has been projected that if they are evicted pursuant to the impugned notices, dated 8/10/2025 and 10/10/2025, they would be rendered homeless in the absence of any alternative provision made by the respondent authorities for their rehabilitation. Full stop. Para. Mr. Goswami, Learned Standing Counsel, Learned Additional Advocate General, Assam appearing for the respondents, has submitted that the Jamuna Modonga Reserve Forest was declared so by a notification as far back as in the year 1918. Full stop. The Lutumai
Lutumai, my lord, I have to check. My lord, I'll give the date, my lord.
Reserve Forest areas have been declared under Section 17. Section 17
17, my lord.
of the Assam Forest Regulation as amended as far back as in the year dash by a separate gazette notification. Full stop. And the gazette notifications had outlined the boundaries of the two reserve forests specifically. Full stop. Para 6. Page 150. While it is contended on behalf of the petitioners that the notices are bereft of the description of the lands, a contra submission is made on behalf of the respondents that the petitioners also have not disclosed about the exact areas of land they are in occupation. Full stop. Mr. Goswami, Learned Additional Advocate General, has submitted that if in any notice he produces any valid land documents like periodic patta, decree, sale deed,
My lord, other instrument.
comma, etc. It will include also decree. Sometimes some persons get decree, expiry degree,
Settlement order from government.
etc. In justification of the parcel of land under his possession, comma, the claim of such notice will be given due consideration. And if the parcel of land of any such notice is found to be located beyond the boundaries of Jamuna Modonga Reserve Forest and Lutumai Reserve Forest, comma, the eviction exercise is not going to be undertaken in such situation against such notice. Full stop. He has submitted that prior to issuance of the notices on 8/10/2025 and 10/10/2025, comma, a joint survey was undertaken. And it was only after ascertaining the coordinates of the said two reserve forest, comma, the notices have been issued to those persons who were found encroaching lands inside the boundaries of the said two reserve forest. Full stop. Mr. Goswami has further submitted, has placed copies of the orders passed by the division bench of this court in PIL Suo Moto number 1 of 2022, comma, writ appeal number 251, 2025, and writ appeal number 252, 2025. And what is that other one?
My lord,
You have shown another one, that is the one.
PL 39, my lord.
PIL
39 of 25.
25. To buttress his submission that the procedure contemplated by the notices dated 8/10/2025 and 10/10/2025 is in conformity with the directions made by the division bench in those cases. सबसे पैरा 3 at page 152. Where is PIL 39?
Page 21 of that bunch of documents, my lord.
Mr. Guya, learned counsel appearing for the petitioners, has submitted that against the judgment rendered in writ appeal number 251, stroke 2025, and writ appeal number 252, stroke 2025, comma, a special leave petition with diary number 629, oh, sorry,
My lord, special leave to appeal C number
special leave to appeal.
236.
C, within bracket C, number 23647 dash 23648 stroke 2025 has been preferred before the Honorable Supreme Court of India and by an order dated 22/8/2025, comma, the Honorable Supreme Court has directed the parties to maintain status quo. He has further submitted that the said special leave to appeal petition is likely to be listed on 14/11/2025. So, in such view of the matter, comma, the respondent authorities shall await the outcome therein. On the other hand, comma, Mr. Goswami has submitted that a division bench of this court taking note of the pendency of the special leave to appeal number so and so.
But that
And the
has not
order
been specifically not recorded, my lord. It is post Supreme Court order. It was placed before the court, my lord. In that order, it is not taken note of, my lord.
Submitted that. Has submitted that subsequent to 22/8/2025, comma, a PIL, comma, PIL number 39 stroke 2025 has been disposed of by a division bench of this court on 10/9/2025.
Wherein, my lord, directions passed in writ appeal was Directed to be followed.
wherein the direction passed in the order dated 18/8/2025 in writ appeal number 2025 and writ appeal number 252/2025 has been followed. Full stop. The notices impugn hearing, that is the notice dated 8/10/2025 and the notice dated 10/10/2025 are in essence show cause notices wherein whereby an opportunity has been provided to the notices to respond to the said notice and to show cause as to why the eviction exercise contemplated therein should not be undertaken against them. Full stop. The noticee has definitely the opportunity to show cause with the support of documents that the parcels of land which are under their occupation do not come within the boundaries of the two reserve forests. Full stop. If the notices are able to show that the parcels of land under the occupation are outside the definite boundaries of the two reserve forests, then the respondent authority does not have any cause of action to evict them. First stop. Mr. Bhuiyan has submitted that in response to the whether all have submitted representation or not?
No, no,
How much time? No, 7 days.
Not 10 days may kindly be given.
Okay.
Mark.
Mr. Bhuiyan has submitted that in response to the notices dated 8/10/2025 and 10/10/2025, all the notices, the petitioners have not submitted their representation within the stipulated period of 15 days. Therefore, an opportunity should be granted to those notices stroke petitioners who have not yet submitted their representation in response to the notices by extending the time period. Full stop. Mr. Goswami, Learned's Additional Advocate General, has fairly submitted that the remaining petitioners can be allowed to submit their representations within a period of 10 days from today. That is up to.
Lord, 10 days.
Give a definite date, Mr.
Milord,
10
today
days.
is Milord 11.
Baro.
Within 20.
21st, my lord.
22. 22.
Mal.
Within a period of 10 days from today, that is up to 22/11/2025. Before the respondent number 6 and the respondent number 7. Full stop. Having considered the submission of the Mr. Bhuiyan justified and taking note of the submission of Mr. Goswami, this court of the view that the remaining petitioner notices that petitioners who have not filed their representations in response to the impugned notices shall be allowed to file their representations on or before 22/11/2025. Full stop. It is ordered accordingly. Full stop.
Para. It is observed that if any representation is received from any of the notices stroke petitioners herein by the respondent number 6 and the respondent number 7, comma, they shall examine such representations and the supporting documents submitted in justification of the purchase of land he or she is in occupation. Post of the order and shall pass a speaking order. Post of the speaking order recording regions. Recording
Committee, my lord, let there be a joint, before passing the order,
Ah.
let there be a joint verification with the district authorities, forest and the revenue authorities.
In the meantime, the respondent forest department shall carry out a joint verification exercise
On the land claimed by the petitioners, man.
with the revenue authorities in respect of the lands, parcels of land. The petitioners herein claim to be in occupation. And the joint verification exercise shall be completed. Sorry, and a report is to be, a joint verification report is to be prepared
Before taking any decision on the representation.
after is to be prepared so that the claims of the notices stroke petitioners can be considered in consultation with the state joint verification report. Full stop. The speaking orders to be passed on the individual representation shall thereafter be communicated to the petitioners stroke notices forthwith thereafter. Full stop. The respondent number 6 and the respondent number 7 shall examine whether the parcels of land under the occupation of the notices stroke petitioners fall inside or outside the boundaries of so-and-so forest and so-and-so forest declared by notifications issued under section 17 of the Assam Forest Regulation as amended, 1891 as amended. Full stop. It is further observed that if any parcel of land under the occupation of any notice stroke petitioner is found outside the boundaries of the so-and-so forest or so-and-so forest, no eviction exercise as contemplated in the notices stated 8/10/2025 and 10/10/2025 shall be undertaken by the respondent authorities. It is further observed that if the parcels of land under the occupation of the notices stroke petitioners are found inside the boundaries of so-and-so forest and so-and-so forest, then the respondent authority in the forest department shall carry out the exercise to clear the so-and-so forest and so-and-so forest areas in accordance with law and as per due procedure. So stuff with the observations made and directions given above, the petition is disposed of.
One correction, if my lord allows, my lord has said that forest authorities with the joint verification with the revenue authorities. Let it be district forest authorities with the district revenue authorities.
Okay,
That will be DF and DCs.
And
district revenue
district
authorities.
revenue authorities.
Deeply obliged.
If they are going to evict us after this entire exercise, some time may be provided to us.
Speaking order will contemplate, I think, 15 days.
That not be recorded because as per division bench order, we have issued that 30 days has gone already.
I think they are following.
Yes, obliged.
You take back this after some time. Tomorrow morning, you collect it.
Or my lord can have that, my lord. There will be cases filing and these are the orders for appraisal. Obliged.
Obliged, my lord.
You give the notification that Lutumai.
I have already given, my lord.
Oh, I can give you.
Lutumai notification.
Timing matter, item number 10.
10.
My lord, the last time the order sheet which I placed, my lord.
10.
Yes. Oh, sorry. I hear standing, that's why I thought. SBI,
My lord, notice to go.
notices to go. Hired Mr. S. Hawk Learned Counsel for the petitioner. Post of the petitioner, comma, a senior citizen, comma, maintains a bank account at Mongoloi Bazar branch of the State Bank of India. Full stop. Maintains a savings bank account number, paragraph so and so, huh? At Mongoloi Bazar branch of the State Bank of India. Has been maintaining since long. Full stop. The petitioner, who is a government servant, comma, retired from service on reaching the age of superannuation on 31/3/2022. And in the aforestated bank account, comma, his regular pension
Yes, ma'am.
gets credited. Full stop. However, comma, since when?
6/7/2024.
Huh?
6/7/2024.
6/7/2024. The petitioner has not been able to operate the bank account. Post one inquiry, comma, the petitioner has found, petitioner has been informed that his bank account has been freezed on and from 6/7/2024 due to a dubious transaction amounting to 12 lakh from an 12,000 from an unknown source. Full stop. Issue notice returnable on so and so date.
Respondent number 23, my lord.
Okay. Having regard to the issue involved, comma, this court is not inclined to issue notice to the respondent number 1 at this stage.
No.
Full stop. Issue notice, issue notice to the respondent number 2 to 5.
No.
The note returnable so and so. The petitioner shall take steps for service of notice upon the respondent number 2 to 5 by speed post within 2 working days from today.
Time of list.
Item 58.
Forest again.
Yes,
My lord, that rice, my lord.
They want to
My lord, we
harvest the rice they have
harvest
planted.
the rice, my lord.
Admittedly, no, I had placed an order sheet last time.
Single judge order I have found, but the division bench.
No, it goes a different way, my lord, because by the way, the time they've approached the DTP, the division bench, the crops were inundated, my lord. It was flooded. So that DTP was not pressed. Mahabhairav. And
We'll try to give a consideration tomorrow,
more, my lord.
Man.
having more time.
Yes, yes.
Because the, my lord, what we have heard, my lord, the deputy commissioner has authorized some of the organizations to collect the crops.
And if it is auction, and it should be
No, my lord.
deposited.
No, my lord, it is not auctioned or not deposited, my lord. It is on the request of some local organizations to the deputy commissioner. Now the crops are being handed over to them to collect and sell it in the open market, which is not at all permissible, my lord.
Either way,
Whatever,
permissible. We'll advise, my lord.
Yes, Mr. Das,
Let
you also think of what? Whatever crop is there, if it is ripened, it can be allowed to cut under the specific authority of the district commission. And whatever money is collected, it's to be kept so that petitioner can be given back the money.
My lord, my lord.
If under law,
if
if
you are
under law you are
yes,
entitled
yes,
at an appropriate time.
my lord, that can be done.
Sir, where is come with a decision? Since the forest area, even a deadly penalty.
So let the money be kept.
My lord.
No, I will ask the
There is no
DC to
one-
stop. We'll ask the DC to stop till it is decided tomorrow.
Kindly, huh?
In the meantime, list the
Yes.
case tomorrow.
My lord. Oblige me, kindly.
Item 71 for orders.
Yeah, Lordship. Lordship, before start, I need to set out the brevity of the case, Lordship.
Hmm?
So, Lordship, herein, Lordship, the order 47 is applicable, Lordship, review petition, Lordship.
Yes, no, why not?
Then, Lordship,
But where is the ground?
Lordship, kindly find, Lordship, either my prayer.
Consent order.
Lordship,
Show me any judgment.
Lordship,
Not only from Supreme Court of India, you can
Lordship, so-
place it from International Court of Justice also.
Lordship, with due respect, Lordship. So in a writ petition, Lordship, so not a single point has been raised in regarding this, Lordship.
When it is a consent order,
So that's why, Lordship, so let me say, Lordship, so
in any view of the matter, tomorrow is going to be,
defend the prayer portion in my writ petition, Lordship. Prayer portion is page 39, Lordship, in my review petition, Lordship, page 39, Lordship.
the more you argue, Mr. Das,
No,
the
not
meter is
only-
going to run.
Only 2 minutes, Lordship, only 2 minutes.
Clock is going to run.
I like to say also only one aspect, Lordship. So prayer portion kindly find page 39, Lordship, in my review petition, Lordship. 39, kindly find, Lordship.
Review petition,
Yes, Lordship.
39.
Yes, Lordship. Review internal page of the writ petition, Lordship. Page 39, Lordship. Prayer portion.
Mr. Das, you may have many reliefs. You might be seeking many reliefs.
So
But when both parties consented to a particular order,
So, Lordship, on that part, I'm sorry for this, Lordship. On that part, Lordship, in the contents of the prayer portion, Lordship, is reversely recorded in my in the judgment, Lordship. So, not a single point has been raised in the prayer. Can you find what the prayer portion in my?
No, we are into the order which you are seeking review.
Yes, Lordship. Just modify little.
Now-
modify, Lordship.
Whether this order,
Page 20, Lordship, the relevant part, Lordship.
whether this order
Page 20, Lordship, the relevant page 19 starts, my lord.
page
20, my lord.
Page 20.
20.
Relevant part is page 20, Lordship. Second paragraph.
Are you
Lordship.
the counsel there?
Yes, Lordship. So.
No,
that
you are not the
part-
counsel there.
Yes. So,
Are you?
Ayuddin, no.
No. So I do love this practice of filing review petition through another counsel is to be deprecated. Judgment also. Repeatedly. Parties have consented.
So that's why, Lordship, I'm trying to, Lordship, raise this query, Lordship. So that part, Lordship, the
No, we are not
recorded,
going to
Lordship.
hear you.
So therefore, Lordship, in my,
Heard Mr. R.C. Das.
so the concern is in the year of 18 notification, Lordship, then that notification wise did not held any kind of the meeting.
Learned counsel for the applicant
And also violation of the section 39 also, Lordship.
and
Assam Cooperative Act.
Miss applicants and Miss M.D. Bora. Learned Standing Counsel Cooperation Department, but there is opposite party number 1, 2, 3.
5 and 6.
Mr. N. Das, 6 also.
Yes, 6 also, Lordship.
Oh,
And
5,
yes,
6.
6 also. 4.
5, 6. And not 7. And Mr. N. Das, Learned Junior Government Advocate, Assam, for the opposite party number 4. Full stop. The instant application under section 5 of the Limitation Act 1963
Review the one and-
is preferred, seeking condonation of delay of 593 days,
98 days.
98 days, which delay has occurred in filing the accompanying review petition. First off, the applicants herein as review petitioners have preferred the accompanying review petition under Order 47, Rule 1 and 2 of the Code of Civil Procedure 1908, seeking review of an order dated 4/10/2023, passed in a writ petition, WPC number 1046/2023. Full stop. in the repetition WPC number 1046/2023, comma, the applicants that review petitioners herein were the writ petitioners. Full stop. The writ petitioners preferred the writ petition, stating that they were shareholders of one Messrs. Khatwal within bracket Rupohi Homabai Homiti, comma, A cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007
2007.
as amended. And their grievances were with respect to non-holding, grievances, grievance was with respect to holding
Annual meeting, Lordship.
of annual general meeting AGM stroke election of the cooperative society in time. Full stop. During the course of deliberation held on 14/2023, comma, it was submitted on behalf of the state respondents that preparation of the correct voter list had been complete and a notification be issued notifying the AGM stroke election of the society. And it was submitted that the writ petition could be disposed of with a direction to that effect. Full stop. The learned counsel for the petitioner therein, who represented the applicants, the review petitioners herein, comma, had agreed to a direction for disposal of the writ petition with a further direction for refund of the nomination fees submitted by the petitioners to contest in the election to the society. First of, the court, having taking note of the respective submissions of the parties, of the learned counsel for the parties, comma, reached an observation that no further direction would be required at the stage, save and except providing that the respondents shall notify the AGM stroke election of the society as expeditiously as possible, comma, but within a period of 4 weeks from the date of receipt of a certified copy of the order. Full stop. The order dated 14/2023 is, comma, in a sense, a consent order. Full stop. Para, be that as it may, we have gone through the statements and affirmance made in this application, seeking condonation of delay of 598 days. It is noticed that despite the order dated 4/10/2023, the applicants herein carried the matter to the division bench by an intra-court appeal, comma, writ appeal number 01/2024. to assail the order dated 4/10/2023. Post of when the readable WA number so and so was listed on
Is 60, my lord.
22/01/2024. A prayer was made on behalf of the writ appellants for withdrawal of the writ appeal with a liberty to file a review petition. Full stop. The accompanying review petition was filed on filed and reported on 14/7/2025. Post of in the instant application. The applicants have stated that they obtained a certified copy of the order dated 22/01/2024 only on 12/6/2027. Full stop. As the order dated fourteen 2023 Supra was an intra-party order and the writ appeal number so and so was withdrawn at the instance of the applicant's hearing. This court finds that there is no explanation in the application not to speak of much less sufficient cause, explaining the delay, explaining the reason why the applicants, what the applicants had done during the period from when the writ appeal was disposed of. Withdrawn?
It was 22/1, lordship.
22/1/2024
May check, my lord.
to 12/6/2025. Full stop. Miss Bora, learned standing counsel. Co-person department has submitted, on instruction, that the annual general meeting election to Messrs. Khatwal So and So Cooperative Society is scheduled on 23/11/2025 and all the due procedures have been followed
Yes.
to hold the AGM election. Full stop. Having regard to the fact that the review petition, accompanying review petition has been preferred against a consent order and there is abject failure on the part of the applicants to explain the delay of 598
98
days.
98
Showing,
days.
98 days. 98 days.
98 days.
Showing sufficient cause. This application is found to be bereft of found to be this application is found to be lacking merit and is liable to be dismissed. It is accordingly dismissed.
Roshni, may kindly
Sir,
keep me-
the review petition in view of the order passed today in IA number so and so. This review petition which is yet to be numbered, is dismissed.
So Lordship, into the Lordship. So the by tomorrow's submission, the nomination paper, Lordship. So I may allow to participate, Lordship.
Already
Lordship.
directed on last order.
So Lordship, the notification dated 18, Lordship. So the violation 39 is clearly defined,
Mr.
Lordship.
Das, don't
So does 39
involve
clearly
the
defined,
court, go
Lordship.
into the merits.
So within 6 months, the election.
You are
already happened.
shareholder, you are quite aware.
Yes.
Yes, Lordship. But
And
what
I'm not writing the region in the order, but I could know why you are filing this, insisting for this application and review petition. You want to derail the process.
So,
My lord,
so
may
the
kindly keep my
department-
instruction the part of the
department-
record, my lord.
Department has.
The instruction placed by Ms. So-and-so is to be kept, are to be kept as part of the case.
I am so deeply obliged, my lord.
39 absolutely valid, Lordship.
We are into only condonation of delay. We are not satisfied.
Yes, Lordship. Yes, Lordship. Yes, Lordship.
Deeply obliged, my lord.
And Lordship, apart from this case, Lordships, I have conferred them the decisions of Justice Book, Lordship. The Barnard P. Hall, Lordship, very much appreciated in this regard, Lordship. So, but one sentence, Lordship.
So
If
this
Lordship-
order is subject to appeal.
Apart from this case, Lordship.
It's subject to appeal.
Apart from this case, Lordship.
No, I don't understand all this English laws and American laws.
Deeply obliged, my lord.
It's okay, Lordship.
It will be better before a higher forum.
So only one sentence, Lordship, I remember.
Okay.
So Barnard.
Let us for the benefit of all.
So he was the first Chief Justice of the High Court of India. He says, Lordship, an unflinching advocate of the freedom of the press, and that such believer is the main bulwark right of the people.
It is for me, OHT. OHT, you know. You know OHT
No,
in a lighter vein. Overhead transmission.
I'm so deeply
Next.
obliged, my lord.
Over the head transmission.
much obliged, Lordship.
Obliged, lord.
Order no steps, item 15.
Yes, those steps.
Yes, Your Lordship, today,
You are not interested.
no, Lordship, today we have taken step, Your Lordship.
Huh?
Today we have taken step.
Oh, after our action, you are taking steps. Otherwise, you are inactive. Miss
M. Medhi, Your Lordship. M. Medhi.
M. Mary Learned Counsel for the petition has submitted that the petitioners have taken steps for service of notice upon the response number 5. In deference to the order dated 18/8/2025 of the Law Jima Court. Today, full stop. In view of such submission, let the case be listed after 4 weeks for service report as regards response number 5. Mr. Andas, learned junior government advocate for the state response, is in attendance.
Obliged.
For item number 16.
Yes, Mr. Kanodia, are you available tomorrow?
Tomorrow,
I asked you.
Lordship, in the morning I was there, but because it was serious.
No, it is not possible.
No, Lordship, that is because it was serial 16, I thought it will reach by 2:30. It will not take much time from my side, Lordship, I'll argue 15 minutes.
Mr. B. Gogoi will appear in this matter, my lord.
Is available.
Available, my lord. He's on his way.
Okay, when?
Now, my lord.
Okay, you wait then, we'll pick up within time.
Lordship. Okay.
You take 15 minutes.
1-5.
Okay.
Great.
Item 17.
My lord, in this matter, we have filed one IA, my lord. Probably it is listed together with the writ petition, my lord. I filed for striking out the name of the petitioner number 2 who expired, my lord.
You have any objection?
No, my lord. No objection at all.
Who is petition number 2?
Petitioner number 2 is Rumina Rahman, my lord. She expired, my lord, on 21st of 21st.
Heard, Mr.
A.N. Sharma, my lord.
A.N. Sharma, learned counsel for the applicants, writ petitioners. And Mr. H. Borua, learned counsel for the learned counsel representing Mr. B. Gogoi, learned standing counsel, finance and taxation department for all the opposite parties. Full stop. The instant interlocutor application is preferred by the applicants. by the applicant for striking down the name of the petition number 2 from the area of petitioners in accompanying writ petition WBC number 4056/2018. Post of the applicant herein along with one Rumina Rahman had preferred the accompanying writ petition assailing a notice dated 18/5/2018 issued by Certificate Officer Taxation Guwahati. Post of Paras. The applicant has averred that during the pendency of the writ petition, petition number 2, namely Rumina Rahman, expired on 21/2/2020. Post of therefore, an occasion has arisen to delete the name of the petition number 2 from the area of petitioners in WBC number so and so. The applicant has further submitted that he, as the remaining petition, would pursue the accompanying writ petition as the right to sue still survives. Post of Mr. Borua, learned counsel appearing for the opposite party, has submitted that he has no objection if the name of the petition number 2 is deleted from the area of petitioners in the accompanying writ petition. You too heard it. Post of as the petition number 2 in the accompanying writ petition has expired on 21/2/2020, and this instant interlocutory application is allowed. Post of the applicant, as the sole surviving petition, shall file an amended cause title before the registry. We need, as per the notification, it is going to within 3 working days from today. Also, on submission of the amended cause title, on filing of the amended cause title, the registry shall carry out the necessary corrections and in the cause title of the accompanying petition as well as in the CIS.
Item 18.
Lordship, kindly peruse the last order. No, instruction last. আমি অলরেডি কমিউনিকেট কৰিছে কিন্তু অহা নাই টাইম এটা ল'ব লাগে So Lordship, my lord, Mr. Nayak is absent today, my lord, due to personal difficulties. My lord, that he told me that the instruction not yet received, so he required 2 weeks time more.
Further 2 weeks time.
Lordship, he already been communicated, but
Okay. Okay, let us fix it on a date.
Lordship.
Heard Mr. Y.S. Manal, learned counsel for the petitioner, and Mr. J. Hendrik, learned state counsel. Post of as per the previous order dated 31/10/2025, Mr. Nayak, P. Nayak, learned additional AG, Assam, is supposed to apprise the court as regards the status of the application of the petitioner submitted for settlement of 1 katha 10 lisas of land. Post of Mr. Hendrik has submitted that Mr. Nayak has personal difficulty today Moreover, post of Mr. Nayak has not yet received definite instructions in a matter. Post of he has thus paid for listing of the case after 2 weeks. Post of in view of the prayer submit, list the case on switch.
2811. Only we reflect the name of P Nayak, Mr. P Nayak.
The name of Mr. P. Nayak, Land Relation AG Assam is to be reflected in the respondent side in the call list.
Oblige, your lordship. Item 19.
May it please lordship, what happened, my lord? This writ petition was dismissed for default, my lord, non-prosecution earlier. Then, my lord, they have subsequently filed a restoration application. I was not served, my lord. Without hearing me, my lord, the writ petition was restored, my lord. In the meantime, I have already handed over the brief to the client, my lord. Although I have already filed the affidavit in this present writ petition, without serving the notice, my lord, the writ petition has been restored.
Even in this case, I would like to file my rejoinder. And I'm seeking 4 weeks time for filing my rejoinder.
Right, but this respondent number 4, are you in contact or not?
No, my lord. All of
So here
brief,
he has to be brought on board. You cannot go on filing rejoinder. Is it not?
Right.
Otherwise, everything will be behind his back. On the previous date, you were there or what?
No, my lord, I had.
You were not there,
Mm.
but who was there for respondent number 4?
I was there, my lord.
So he made submission regarding title suit.
Yes, my lord. There was a title suit pending, my lord. Accordingly, my lord, the writ petition has been dismissed for non-prosecution, my lord. But subsequently, they have filed a restoration, but I was not. my lord,
Yes,
served, my lord.
yes, no?
No, restoration was not allowed. Then I filed on writ appeal, my lord. The appeal, the
And all is behind my back. I am not aware at all, my lord.
restoration petition.
Lord, Mr.
Writ appeal also been filed
Yes. writ appeal.
without making me as a party
No, the
respond.
party, it pleaded, but the Honorable Chief Justice had.
One of the network person.
By which order it has been restored?
My lord, in the appellate, my lord, before the Honorable Chief Justice, the division bench. It's marked as.
Post of
X.
Mr. Ms. P. Chakraborty, learned counsel for the petitioners. And Mr.
I am Shiladitya Lutfi.
Siladita, learned counsel, who is to represent the respondent for prior to the dismissal of the writ petition due to non-prosecution on 24/3/2025. Post of Mr. Siladita has submitted that after dismissal of the writ petition on 24/3/2025, he had returned the brief and presently, he is not in contact with the respondent number 4. His client, that is the respondent number 4. Post of in view of such submission of Mr. Siladitya and counsel, let notice be issued to the respondent number 4 for his appearance. The petitioner shall take steps for service of notice upon the respondent number 4 by speed post within 2 working days from today. Sorry. Then town committee is also.
This is a government issue party.
No government, town committee, can you represent? এটা লিখিব, N Das লিখিব, junior government advocate. Assam for the respondent number 1 and 2. Urban Development Department and District Commission. The petition shall take steps for service of notice among the respondent number 3 and the respondent number 4 by speed post within 2 working days from today. Release the case.
Obliged. Item 20. What matter is this one portion of my land was earlier donated to the army defense, but army extended to my other plot also. Therefore, I applied before the circle officer to demarcate and make a joint survey. That was not done. So basically, that is my issue. And the defense already submitted one reply saying that in the 18, one joint survey was there, but thereafter no joint survey was there. So matter can be disposed of by directing the circle officer to conduct a joint survey regarding my land.
I got an instruction, but affidavit is yet to be.
That is my simple prayer, man.
One thing is the lordship may create next statement paragraph 2 madam. They enclose according to his mother Doma Bandi madam. There is no Doma Bandi. Yes.
Then Mr. Das, file your
Yes,
affidavit.
that will be better, my yes, my lord.
We'll give consideration.
Well,
And that
Mr. Hart, Mr. DK Nath.
paragraph 2 madam.
Let him file the
Affidavit.
instruction, affidavit.
No Doma Bandi.
Let him file this. You are not the land authority, he is the land authority.
Yes.
DK Nath,
well,
Learned Council for the petitioners. Mr. SK Mehdi, learned CGC for the respondent number 1 and 2. And Mr. N Das, learned junior government advocate Assam for the respondent number 3 and 4. So subdivided. Mr. Das has, a junior government advocate has submitted that he has received the SA instruction to file the counter affidavit on behalf of the respondent number 3 and 4. And has sought for how much time?
My lord,
2 weeks time to file the counter affidavit.
Can it
Full stop. As paid for by Mr. Das, raise the case after 2 weeks. So that the respondent the respondent number 3 and 4 shall ensure that its counter affidavit is filed within 2 weeks time.
Three, can it be true? Can it be true?
One page parawise comment. Why chief?
matter is actually very simple. That can be disposed. My next item,
Oh,
it is my
okay, to raise the case on DD 22 na.
well, this matter is very unfortunate in
My
spite
lord,
of repeated.
I got some instruction, my lord. If a lordship got.
What is the case about?
My lord, this, the order dated 6th of February 2023, my lord's order, it described everything, where one of the building, common building, one part was acquisition, land and building, and the adjacent part is mine, the cousin. So during the demolition, my part was also damaged, but as
Okay.
per section 3G, that is to be surveyed, but that was not done in spite of repeated letters from the Kala as well as circle officer.
Who has filed affidavits here?
The
5 and
NHIDCL.
My lord,
5 and 6.
And interestingly, my lord, as per order dated 9th of August 2023, this honorable court sent the matter to the PWD for survey, and that calculation is also there. My lord, may kindly see the additional affidavit filed by me. Instead
Yes,
of-
what kind of instruction?
Mother, it says, my lord, that in connection with the incident present a claim of the petitioner for the damage occurred to his building, if any, is stated to be the structure building owned by the petitioner, that is Mohammad Farooq Hussain, is not within the ROW, right of way, demarcated by NSI DCL. In NSI has no valuation. Estimate for the building of the petitioner was submitted by the PWD Jordan.
That is the fact, that is the case of the petitioner. That is the case of the petition at the time of filing the writ petition. I think that is the case.
Yes. And as per the order of the.
So what subsequent steps you have taken after issuance of notice?
And PWD has already submitted the valuation, madam.
Because on representation being made, the competent authority land acquisition, respond number 3, by letter dated 24/9/2021, had called for a report from the respond number 4 to examine whether the demolition of one part would make the other part not habitable, and all this are there.
Well, sometime, madam. Again, I'll communicate it, madam.
And that report is there, madam.
You go to the previous orders also.
Yes, madam. But sometimes.
They cannot for the petitioner. And last line, junior government advocate Assam for the respond number
234.
234. Post of. It is noticed that in this petition filed in the year 2022, no contributive assessment filed on behalf of the respond number 234, post of Mr. Das has submitted that he be granted 3 weeks time to complete his instructions and to file the contributive on behalf of the said respondents as a last opportunity. Post of. In view of the above prayer of Mr. Das, let the case be listed after 3 weeks. Post of. In the meantime, the respondent number 224
PW.
shall ensure that his contributive is filed before 3 weeks.
Report true. Sir, may I pray for a date, madam?
Did you do?
5/12. Well. Items 22 to 25.
May I please, your lordship? In this case, I am for item number 24, my lord. Here's the analogous.
What is the subject matter?
My lord, the petitioners has been allotted Bajar Bita in Bajar Bita, Bita room, my lord, to the petitioners by the Lanka Municipal Board.
Where allotted?
Yes. Thereafter, the municipal board collected rupees 50,000. Thereafter, as aid, my lord. Thereafter, they have collected tax also, my lord. And we have been also directed to construct our own Bita by our own, my lord. We have accordingly done it, my lord. And when the work is almost complete, my lord, the impugned order has been passed with the deputy commissioner, my lord. That is at page 70, my lord.
Page?
Page 70, item, annexure I, my lord. In item number 24, my lord.
24 to the item 24. Horipada. 70 page to some.
24/1064.
Yes, my lord, 1064.
Page?
Page 70, last page, my lord.
70.
70.
এইটো তুমি এফিডেভিট দিয়া নাই মই ইমাত্ৰ পালো ফোনত পালো
That is dated 18 July 2021. Pursuant to this letter, my lord, the executive officer of the municipal board has stopped the last finishing word of us, and we have been stopped to operate the budget meters, my lord. Prior to that, we have already invested our money. We have constructed, as per their instruction manuals, we have constructed our budget meter, my lord.
That is the construction part. But what about the allotment part?
Allotment part is that is allotted to us, my lord,
By following a procedure?
by following procedure.
Yes.
Yes.
And affidavits are filed.
Well, in item number,
This petition affidavit is not final.
item 22 to 25, well, these are similar matter. Well, the allotment is not in question, but in the meantime, when the allotment process was done, some complaints came as regard construction, quality of construction of the building. And therefore, my lord, finally, the deputy commissioner has undertaken an inquiry as regard the quality of construction of the building. During pendency of the inquiry, till the report comes, ultimately they were stopped. So from our side, my lord, if we can allot them, it is good for us because we will earn something. Otherwise, there is no earning. My instruction is, my lord, that the deputy commissioner has already, my lord, the hearing has been taken place. Persons, complainants, they were all heard. The representative of the board were also heard, my lord. Everything has been recorded, but the final report has not come.
5 years.
That's true. That's true, my lord. Lordship.
This is too much.
Lordship, my lord, in fact, the board authorities have informed that they have pursued the matter because of some situation, my lord, it has not come.
Then it is the deputy commissioner who is responsible for the delay.
My lord, that is why, my lord, I pray, my lord, that Lordship may keep it after 2 weeks, my lord. In the meantime, my lord,
And
the
get the things done
Lordship.
within 2 weeks.
Yes, my lord. In the first week of December, kindly keep it. And by that time, my lord, we'll take up with the deputy commissioner, my lord. Because hearing and everything has been taken place long back. I am informed, my lord.
Heard, Mr.
I'm B. Chanda, my lord.
Haldar.
Chanda, B. Chanda, my lord.
B. Chanda, learned counsel for the petitioner.
I want to.
You are in one. Who are the others? Miss L. Wazira. T. Begum. Okay, B. Chanda, 24. T. Begum, you are in 22. And Mr. Dinath, learned senior government advocate for the state respondents. Post of. On the Mr. Nath has submitted that he be granted 2 weeks' time to place instruction as regards the outcome of the inquiry initiated by the district commissioner. Ho jai.
Ho jai, my lord.
Pursuant to the MP notice dated
That is 18 July 2020, my lord.
18/7/2020.
Petition.
Post of it. As sought for by Mr. Nath, release the cases on so and so.
Date will
But
be
next date, I have said.
Lordship.
5/12.
Items 26 and 27.
In this case, my lord, into item 27, I have filed Okalatnama today for respondent number, my lord, 3, my lord. So, my lord,
You'll file counter.
yes, my lord, 2 weeks time may be given, my lord.
CRP 2015?
It was initially filed, my lord,
Huh?
And it was converted to WPC later on.
a revenue board's order was silenced, my lord. That was
Okay,
mistake.
Mr.
MJ Gogoi, Lord.
MJ Goyal, learned counsel for the petition is present. Mr. H. Das, learned counsel has submitted that he has entered. Oh, you have already entered in the earlier date.
Earlier case, my lord, yes.
And Mr. H. Das, learned counsel for the respondent number 2 and 3. Post of Mr. Das has sought for and is granted how much time?
2 weeks time.
2 weeks time to file a counter affidavit on behalf of the respondent number 2 and 3. Post of release the case after 2 weeks.
Obliged.
Any interim order?
No,
Yes, interim is there. Interim may continue, Lord.
Interim order is there.
possibly status quo was there, man.
Interim may continue, Lordship.
On the interim order passed earlier shall
Obliged, Lordship.
continue till the next.
Item 30.
This matter.
Matter is
Just on
listed.
my instance, Lordship. Lordship, what had happened,
Matter
Lordship?
is agreeable from however the rest technical areas that they are not interested in that what the other two medium areas of file. Yes, really
Lordship,
file.
Lordship, on page 28, the eviction notice which they are challenging, we are withdrawing this notice, Lordship, because this was not as per PP Act, Lordship. So we want an liberty from this court to withdraw this.
So if the withdrawals, the
Lordship.
disposition is becoming for.
Yes,
Lordship, takes the
Page
matter-
28.
yes, this notice,
And what is a matter of challenge?
this notice, eviction notice, Lordship, we have given this. They have challenged this. This was not as per Act, Lordship.
So we are withdrawing this, as there was a status quo is there, Lordship, so we can.
It affect was the undated impugned order issued by the shown in the petition 312. What is the 312? What is 312?
Lordship.
In a repetition?
Lordship.
We got received the notice.
They
Huh?
they have received this
They have
page
received-
28. Page 28, they have received this notice.
PS 28.
They have received this notice, Lordship, 312.
This is what you have challenged.
Yes.
This is undated notice, this
Huh.
not followed the.
But you were saying impugn order. Let us see the synopsis, then we'll understand.
Lordship.
Synopsis. Okay, the petitioners. Heard, Mr.
C Talukdar.
C. Talukdar.
Lordship, may fix the matter next week, any. Okay, the conducting council, A Gautam is out of session, that's why. With some factor here, we have filed an additional affidavit.
C. Talukdar, Learned Counsel for the petitioner. Petitioners. And Mr. S. S. Roy, Learned Central Government Counsel for both the respondents. Most of the writ petition has been preferred. Assailing an eviction notice issued by the officials of the respondent NF Railway. Post up. The main ground of challenge is that the eviction notice is vague and does not contain any specific names, dates, addresses, reference, etc. Full stop. Mr. Roy, Learned Central Counsel, appearing for the respondents has submitted that as certain omissions have been made in issuing the eviction notice, the respondent NF authorities have withdrawn.
Lordship, as status quo is there, so we could know.
Intend to withdraw the said eviction notice, impugned eviction notice, as a status quo order is operating in this petition.
Lordship,
They are not in a position to withdraw the petition, withdraw the eviction notice. Post up. At this stage, however, Mr. Talukdar has sought listing of the case on another date to complete his instructions. Let the case be listed again on next Wednesday.
19.
Obliged.
Items 31 to 35.
Readings complete.
Yes, my we file affidavit. Yesterday we file
All
affidavit.
complete.
Lordships.
Recently
they have been filed.
Admission hearing. Admission hearing.
Okay. All right, Mr. J. Ahmed, Learned Counsel of Petitioners. And Mr. J. Henry Learned Junior Government Advocate from Ms. P.R. Mohanto, Revenue. And Mr. J. Henry Learned Junior Government Advocate for the official respondents. First of all, Learned Counsel for the parties have submitted that exchange of pleading is complete and these cases can be listed on another date to give consideration. First of let the cases be listed, not in this way, on a date in the month of January 2026. In the admission column.
Affidavit may be.
Admission column.
I will.
Admission column.
What's this? Items 36 and 37.
এইটো কিবা আছে ন চাব লাগিব এইটো পাঠা
May I please your lordship, as per order dated 18/7/25.
87, 2025.
25. Respondent has said that they will release the claim if once we will file our claim petition regarding the acquisition compensation, and we have filed our claim petition on 19/7, your lordship.
97.
19.
And who is the concerned authority who will release? Who? Who is the concerned authority who will release the compensation?
It's a DC.
DC.
DC. Who represents DC? Mr. Hendrik. Yes. Any instruction? Any instruction subsequent to
Lordship,
August?
August, no, Lordship, but it is the instruction of July, Lordships.
Yes.
July is old, I think.
Lordships, no instruction.
So, show it to Mr. Sharma, whether it is of any relevance or not. Miss
P. Sharma on behalf of DC.
P. Sharma, Land Council, appearing for a petitioner in petitioner has submitted that the claim petition seeking disbursal of the land compensation amount has already been submitted before the competent authority on 19/7/2025. And the outcome of the said application is not yet known to the petitioner. Also, Mr. Sharma, R. Sharma, Learned Counsel for the respondent, ATT, that, right?
Yes. ATEPFO.
Long name. ATEPFO authorities is failed. Mr. Hendrik, Learned State Council shall obtain instruction. But Deputy Commissioner is a party or not? No party.
Deputy Commissioner is a party.
Huh?
Is
He is-
Lordship, four Lordships.
Amended cost title or what? Okay.
Yes.
Shall obtain instruction from the respondent number 4 as regards the status, present status as regards disbursement of the land compensation amount to the petitioner. Assessed in favor of the petition.
Lordship, my lord, that in that letter it is stated that Lordship, there's some documents they have to, my lord, the claim petition has been deposited before the, my lord,
Whatever, that is in July.
Lordship.
We're in
Regarding,
November.
regarding bank,
When
bank details.
money is
and-
involved, they will definitely try to comply.
Lordship, they have to deposit it, my lord, the bank details and the PAN card.
All have been
After that,
submitted. Those are old things.
Lords,
Your lordship, interim order is
List the case on date of the review. The interim order passed earlier shall continue till the next set of listing. List the case on 28/11.
obliged, your lordship.
Further matter, item
Book
16.
Cases, huh? Yes, Mr. Gogoi is available.
Mr. Google head count.
Whether Lordship will have to go from the first or my lord, only 1 point. you
I have forgotten, Mr. Kanodia has relied on House of Lords,
Yeah.
Lord Diplock and all.
It's
Lordship,
there in one judgment, my lord, which we both are relying upon.
Lordship said
So,
on the last occasion that House of Lords judgment, the Lordships are told to search for that judgment. What is the words used in that judgment? Otherwise, Lordships,
Post the Andhra Pradesh High Court, the Telangana High Court has also now followed the division bench of both the high courts, have followed those judgment and passed orders, setting aside saying that the date, the month would mean the exact date of the subsequent month or the previous period.
Right, but I
Lordship
have a
was-
bit of dilemma.
Lordship-
I am saying that just to know this, okay, all this law
Lordship.
is applied.
Forward. Lordship, I indicated on the last.
Right.
I remember, Lordship.
And the statutorily recognized mode of calculation is section 9,
Lordship.
right?
Lordship.
Exclude the day and include the last day. Now, here is a case. Earlier, normally, it used to be 31st of December.
Lordships.
In other years,
Lordship.
an exception or whatever, an amendment has been carried out. Otherwise, it is 31st of December.
Lordships.
Right.
Lordships. Lordships.
Ought to have been 31st of December 2024,
Lordships.
right?
Lordships.
If I remember correctly.
Lordships is correct. Lordships.
Now, from your side, what will be the last date of the notice? In that case, had it been 31st of December 2024?
Had it that, Lordship?
Yes, had it been.
Lordship, my financial year is 2021, 31st December 21 was the normal due date of annual return under section 44, as is followed from your lords. Now, 73:10 says order has to be filed within 3 years from the last date. 3 years. So that would have been 31st December 2024. And 73:2 says, Lordships, that show cause notice should be issued 3 months prior to the last date of order.
At least 3 months.
At least, minimum. So the intent of the legislature to nomenclate like that is that I should have a time gap of 3 months to reply and to conduct a personal hearing. The essence is there under section 75 also. That minimum 3 adjournments can be obtained by the person to whom the notice has been issued.
No, that is why, had it been 31st of December 2024, and would have been normally done.
Lordship,
Since the amendment.
So 3 months
What
would be
will- what will
30th
be-
September.
30th September.
Because that would be the last date of the month. It could not have been 1st of October. Lordship, that is what the judgments have held. When in the, because there are 30, 31st and 28. These are the various dates in which a month can have. So whatever the judgments have been delivered in this context, Lordship, it has been held that when the date is available in that particular month, that particular date, or the last date of that particular month. So in my case, Lordships, because, and Lordship, I'll just say 17-18 was also a case of extension. Why 17-18 also, the board extended the time. And there the last date was 6th of August 2022 or 24.
There is no difficulty.
Let's say 6th
6th
of August.
August, there is no difficulty at all.
Because in that case, the department is not saying I will issue the show cause till 30th of August.
That is not the case at all. Only difficulty arises
Lordships.
when it is the last day of the month. Because the last day of the month is also related to, because I don't read the provision regularly, so
Lordships. 73 Lordships.
if you, what is the relevant rule related to 44?
Lordship, relevant rule is rule 80 Lordships. Rule 80 annual return Lordship.
Mr. Commander, why don't you stay back for tomorrow? We can hear you in leisure.
Lordship, then in next, Lordship may give one date, Lordship. Tomorrow there's some again fixed matter. Today I took adjournment in another court, so I will have to be there, Lordship. Otherwise, I would have stayed.
Only hearing day, because we are also running sort of.
Lordship may fix a date, Lordship, see, giving some clarity.
Because
I will be there, Lordship.
Because I am finding it a bit intriguing.
Lordship,
The issue is a bit intriguing. Not, I'm not.
It can.
I'm not readily accepting the version of Andhra Pradesh High Court.
Lordships, I bow down to that, Lordship. That is why your Lordship had indicated that it needs some further application of mine by your Lords. Lordship, and then
Not readily, not readily.
Not-
Corresponding date rule, yes.
Yes.
That is there.
that is
Right. Section 9 is also there of the General Clauses Act.
General Constitution Act, Lordship, it defines what is month.
Right.
335.
And that when, and in absence of any specific thing, that is to be applied.
Lordship, I would,
Right.
I would.
And all the related things.
Lordship, so that,
That 31st December has been changed to 28th February.
Lordship, because the last date is not available.
Right.
Because that is the last.
Now,
of the-
if you go by, suppose if you accept
Lordships.
30th November, just
Lordship, for the sake.
hypothetically,
Lordships,
then also it satisfies.
then also it satisfies. It satisfies.
It satisfies.
It satisfies.
Right. And if you take this corresponding date, which you are always going forward,
Forward.
as per the General
General-
Clauses Act also,
Lordships.
right from Tarun Chandra Chatterjee and this, what is that? All the, going forward.
Lordships.
What is the method of calculating back?
That is what Lords, that is what my Lords has to decide now.
The Honorable High Court,
Andhra-
they simply applied the corresponding date.
Corresponding, and that was followed lately, Lordship, after your Lords has interfered
And readily followed.
by Telangana.
Maybe readily followed.
Not really for it's a one-pager order relying on the judgment.
That is why I am not very satisfied.
No issue, Lordship. Lordship, then in that case, may I request for 26th as top of the world, Lordship? 26th I am here, Lordship. That is a,
No, there is.
or some preference may be given so that we can conclude.
No, I would have.
Today,
But
Lordship.
no, that date will not be possible. I might not be here.
Lordship. Then
First week of December
First.
or third week of December. First week is better.
Lordships. Lordship, may give me any date in that case.
Tuesday or Thursday?
Lordship, then 4th of December,
No, Friday, not Friday.
Thursday.
4th of December is
It's Thursday.
Friday.
Thursday.
It is Thursday.
That is 2026.
My lord.
Okay, due to paucity of time, the case could not be taken up today, as sought for and agreed to by Mr. Kanodia, A. Kanodia, learned counsel for the party, petitioner, and Mr. B. Gugoi, learned standing counsel, Finance and Taxation Department. Release the case on
4th,
2025
25.
as a part third matter.
Lordship, some
That
clarity
you
will be-
make a mention, I'll take up.
Lordship, today it was serial 16. So in the morning I was standing, I didn't
no,
time I
no.
like to mention.
No, all these eviction cases,
Much.
not possible.
Grateful.
Item 38.
38 I appear for the petitioners.
Here we have got the instruction, my lord. On behalf of the state, we will be filing within a week. So let it be on the same day, my lord. It will be convenient for him also.
Okay.
Lordship, interim order in the last case also and this case also.
Interim order, go to the Kirimo. Mr. A. Kanodia, learned counsel for the petitioner.
No, date to.
We have filed our affidavit in reply to the counter filed by the respondents for
Central.
Central GST, Lordship.
Petitioner and Mr. B. Gugoi, learned standing counsel, Finance and Taxation Department for the respondent number 1, 2, 3,
1 to 3.
4,
1, 2, 3.
1, 2, 3.
Right.
And Mr. K. Jain, learned counsel for the respondent CGST authorities for the respondent number 4 and 5.
No, 6 also.
6, first up, Mr. Gugoi. Learned standing counsel, Finance and Taxation Department has sought for and granted 3 weeks time to file the counter affidavit, first up, place the case on. Same
Except, Lordship, interim order is there.
interim order passed, I shall continue till the next.
Grateful.
Madhu Sastry. Wait, your Lordship.
Please, your lordship. Your lordship, since the name of social justice was not reflected in the course list, we were unaware that the matter was listed today, and therefore we couldn't bring the relevant file. Therefore, I humbly pray before your lordship to give us give us a next date.
Okay, relevant file, okay. But you are for whom?
Social justice.
Social justice.
Yes,
So you need to do what?
we have to,
So they need to do what? They need to file their counter or they need to bring the records?
yes.
You're supposed to produce the records on today, Lordship, as per the last order.
Ground shown brief not
Lordship.
brought. BK Gogoi petitioner.
Lordship, interim pair, Lordship. Lordship is the police teacher, Lordship. Then the.
No, at this time, issue without, because the interim prayer was meant for only after consideration of the relevant records. We'll fix a date.
Lordship, what happened, Lordship? Lordship, kindly, Lordship. He is a college teacher, Lordship. There was an hearing, Lordship, on 4th of November, Lordship, in the office chamber of the Deputy Director of the Higher Education, Lordship, Kahili Pada, Lordship. Regarding the same issue, Lordship.
4th of December.
4th of November, last 4th November, Lordship. This month, Lordship. And last Tuesday.
Yes, what to do?
And it was informed to the presentation that the authority will issue suspension order against the petitioner based on an erroneous findings of the.
But this, they have cancelled the certificate.
Lordship, that is
Definitely after
without affording
a
any
proceeding.
without affording any
If that is
opportunity
so,
of hearing,
definitely
Lordship.
will consider let the case be, record be brought.
That is the bad, Lordship. Without affording
Mr.
any opportunity of the hearing, Lordship, they will cancel the. They have
It is
cancelled
not
the caste
possible,
certificate
Mr.
of the
Gogoi.
petitioner, Lordship. Lordship, while till next day, Lordship.
No,
Still the
no,
operation of the impugn order, Lordship.
no, when,
Lordship will find the impugn order page 16, Lordship.
we'll keep it open.
Lordship.
We'll keep it open.
Lordship.
Consideration of the interim pair. We'll give him 1 week time to bring the record.
Yes.
We'll give the consideration. Right. You are for madam?
Social justice.
Which respondent? 3. 2, 3 and 4. Mr. Dhar, you are for?
I will appear for number 2.
2.
My lord, 3 and 4.
J. Hendrik Lana, Junior Government Advocate, Assam for the respondent number 1, 5 and 6. Mr. R. Dhar, Lana, Standing Council, Tribal Affairs Department. For the respondent number 2 and Miss
PCA.
PCA,
Yes.
Learned Council for the Learned Standing Council. Social Justice and Empowerment for the respondent number 3 and 4. On behalf of Mr.
RM Das.
R.M. Das. Ms. So-and-so has submitted that the consent brief has not been brought to the court today and has sought for listing of the case on another date. So that the records of the proceedings can also be placed in deference to the order dated 23/5/2025 post of. In view of the above submission by on behalf of the respondent number 3 and 4, release the case on 24/11/2025.
Much obliged.
The prayer for interim relief is kept open for consideration on the returnable.
Obliged.
Much obliged.
Item 41.
It
My lord,
comes-
matter related to my lord cancellation of my GST registration, my lord. Issue is, my lord, in fact, squarely covered by Honorable Telangana High Court and Delhi High Court decision. My lord, may kindly come to SOCO's notice, my lord. Page 60.
If that is so, we'll put it on a date. Now today not
My lord,
possible. I have
yes,
to
the
anyhow
hearing-
rise.
It will be hearing day if your lordship will take.
Yes, Mr. Setia, is it covered or not covered?
No, Lordship.
Or some contentious issues are there?
Yes, Lordship. My lord, what was there, my lord? In fact, my lord, his registration was cancelled, my lord, on the ground that, my lord, it was obtained on fraudulent means, my lord. SOCO's notice was issued, my lord. He has not submitted any reply, my lord. And in fact, my lord, there was a, my lord, inspection report, my lord, which says, my lord, there was no principal place of business at all, my lord. But it needs some consideration, Lordship.
Pleadings complete.
Complete means they have filed, my lord, it is because question of law is involved, my lord. If your lordship will go by SOCO's notice, my lord, it is the reproduction of, my lord, section 29, 29, my lord, 2E.
Okay, A. Goel for the petitioner. S.
Tuesday,
Tetia, Alliance Senior Standing Counsel.
And for 2 and 3 lot.
Which department? CGST.
Lordship.
For the response number 2 and 3.
Lordship.
Mr. Kyle, you are for?
4. Intelligence officer, this is
3 and 4.
I'm appealing for 3.
3.
Mr. S. C. Kyle. Learning Council for the response number 4. H. Borua, Learning Council for the response number
5, 6, and 7.
State of West Bengal.
West Bengal, they are supposed to file affidavit, my lord. But affidavit has not been filed. Today the matter was fixed.
5 and
5, 6, and 7.
no, who is remaining to file affidavit?
5, 6, and 7. Otherwise, my lord, may I pray your lordship, so far as seizure part is concerned, it was done by West Bengal. I will approach the concerned authorities. So I am not pressing, my lord, that part. So it may not be required, man. Because of that, it is delaying, matter is delayed, your lordship.
We'll file our affidavit, my lord. We have sent it for vetting. It has gone to
You
West
have,
Bengal, my
you
lord.
have sent it for vetting.
My lord. Just to come back to us, my lord.
How much time you need?
I'm praying for 1 week, my lord.
1 week good enough.
Thursday, my lord, hearing them.
Sir,
Let them file the affidavit then only. Sorry.
Monday we can file it, man. Probably I will get it by tomorrow.
A. Goel, petitioner.
It is 26.
So you are number 1, Miss CGC 1. S. Setia, Senior Standing Counsel. CGST 2 and 3. S.C. Kayal. Response number 4. Mr. B. Gugoi,
5, 6, 7.
Learned
Council member.
Learned Counsel for the response number 5, 6, 7. Those are present. Mr. Gugoi has submitted that the counter affidavit on behalf of the response number 5, 6, 7 would be filed within 1 week's time and has thus sought for listing of the case after 1 week. The other respondents have already filed their counter affidavits. So place the case on 24. 24 of this month.
20?
24. Let them file there, so you can post it
Man.
on a hearing.
25th, my lord, hearing day.
Let them file.
Apply.
42.
Your lordship, on the last occasion, they had sought a day's time to file the affidavit. Lordship.
Lordship,
Bank accounts.
Lordship, on the last occasion, we prayed for 1 day time, but Lordship, after signing it seems that redrafting has to be done. It has been done. Lordship may take it up on Wednesday, Lordship. By that time, we'll file.
Okay. As the Learned Counsel for the petition is present, Mr. B. Chaudhary, Learned Standing Counsel Finance and Taxation Department has sought listing of the case on Wednesday, huh? So that he would file the counter affidavit within that time. So raise the case accordingly also.
Much obliged.
Item 43.
May I please, your lordship? My lord, issue is simple, my lord. Petitioner wants to sell her land, my lord. And for that purpose, my lord, I have already got non-encumbrance certificate. Then for 50 also issued in my favor, my lord. But my lord, NOC, my lord, sale permission has been rejected, my lord, on the ground that civil suit is going on. But that is not correct, my lord. Because my
Lordship, my lord, I'm waiting for the instruction, my lord. We already been communicated, my lord. Instruction not yet received.
Okay.
My tag number, partner number different, my lord.
Even then, Lordship, my lord, if it is there, they go for the appeal, Lordship. Suppose, my lord, appeal provision is there.
AFNU Mula. Learned Counsel for the petitioner is present on the request of Mr. J. Hendrick, Learned Counsel for the Learned Advocate for the state respondents. Raise the case on so and so. To enable him to obtain the necessary instructions.
Or may I prefer
After
it
2
weeks?
weeks.
I mean,
We are giving it.
Lordship, 2811.
2811.
Item 44 is a refund matter. My refund is IGST paid on exports. It's an automated process. It is stuck since last 1.5 years. On the last occasion, they took time on the ground that instructions are being awaited. But for a similar matter, Lordship of 2020, they have refunded in the month of September after 6 years. That matter, we are waiting for the interest claim that is posted on 26 Lordships. This is a subsequent period. It's an automated process of the law under Rule 96 Lordship envisaged. But the Customs Department and the GST are not refunding. In this case, the amount is 42 lakhs, Lordship. My claim is for the refund as well as the interest. The statute provides, Lordship, after 60 days, the interest starts.
Lordship, I have obtained instruction today itself. They said that it is under process.
21, 26.
Lordship, 26.
2611.
26 will be a very short period. Lordship may fix in after 8th of December. Lord.
After 8th of December.
Lordship, they are not giving it for the 2020 petition also. They are not giving interest. This petition, they are not giving with a tax.
If you are statutorily entitled for interest, you will get.
Lordship, but first the tax on, they are not, Lordship, 1.5 years, my 42 lakhs I have paid from my pocket because it's the export I cannot collect from my customer. It's an automated process, but.
So, Mr. Kyle, you ensure that your
Lordship, what happened
file by 8th of December.
in earlier case, Lordship, there was a mismatch in their bank account. They provided bank account, then it was released, Lordship. Okay. It was their fault, Lordship, not our fault.
Mr. A. Kanodia, and customer petition is present. First up, Mr. S.C. Kyle, Standing Council, Customs Department has submitted that at 2 weeks' time would be required for filing a detailed counter affidavit. Post up. He has thus sought for 3 weeks' time. Post up. Now, praise the Lord, release the case on 10th of December.
Only by that time, Lordship, money will be there. By that time, money will be there.
If I
Lordship.
Lordship, my claim of interest may be just recorded. Lordship. One line.
No, it will be there. If you are statutorily entitled, who can stop you? No court can stop you.
Great.
45 to give. 45 to give.
Item 45.
My Lordship, in this case, Lordship, he appeared as a caveat on the first date. And today he was fixed for production of record and the disposal of this matter. Because, Lordship,
Not possible, which
Not
is
possible today,
which is not possible,
Not
don't ask
possible.
for it.
yes,
I may be allowed,
These are reasonable prayer.
I may be allowed to file affidavit, Lordship.
What is the issue here?
Lordship, issue here, Lordship, the first meeting of clearing in the Gaon Panchayat president
First meeting, okay?
was cancelled, Lordship, by the annexure, Lordship, 9 page 53. On the ground, Lordship, as per 46(3) of Assam Panchayat rule, it is ordered as if at least 3 member is not present, that meeting would be deferred. They have taken the ground that because 3 members were not present, already 6 members present. Because 3 members were not present, that it has to be cancelled. The deputy commissioner has acted upon.
Who has the records?
Lordship, deputy commissioner will produce the record.
Huh?
At least record is also not necessary. In the face of the order, it is manifest that rule 46 has been violated.
Yes, Mr. Hussain.
I may be allowed to file affidavit. Some interpretation is there, Lordship.
What interpretation?
Lordship, section 18, subsection 5 says that 1/3 is the quorum for meeting of the Panchayat. And this rule says first meeting to constitute the Panchayat, Lordship.
Yes.
Okay, you represent whom?
I am for the private respondent 8 to 11, Lordship.
8 to 11.
And there behaves.
You need how much time?
2 weeks, Lordship.
They
will be
are
reasonable.
very fast on the by filing caveat they have entered appearance. And
Status quo is there, Lordship. Nothing will.
status quo deputy commissioner is running, and that constitutes.
Status quo is there.
Lordship.
Lordship.
Neither they are running.
Lordship.
But Lordship,
PP Datta for the petition. Anybody else? Please tell. Oh, you are also private respondents.
yes, sir.
Okay. You want to file anything? Then don't say it on the next date.
I do.
Okay. You are Miss P. Thapa for S. Datta, Standing Council.
1, 5,
1, 4,
1, 4,
1, 2, 4, 5. And 7. Who is the authorized officer? Okay, Mr. J. Hendrick. Unicorn Advocate Assam for the response number 3. 3. Yes, madam, you are 6 or not 6? Not 6. Or 7? Okay, 7. 6 whole, 3 or 6, Hendrick. Mr. M.K. Hussain. For?
Response number 8 to 11.
8 to 11. Mr. A. Bhattacharya. 12 to 16. Any other remaining? No. Okay. Mr. Hussain has sought for and is granted 2 weeks time to file affidavit in opposition on behalf of the respondent number so and so. Mr. Bhattacharya Learning Council for the respondent number so and so has submitted that there is no necessity for the respondent number so and so to file any affidavit in this case. Post on. Mr. Hendrick, Learned State Council representing the respondent number 6 shall obtain the relevant records of the proceedings of the first meeting of the Panchayat. List the case on so and so. The earlier order of status quo shall continue till the next date of list.
5th December.
Right.
I have to rise.
The small prayer in respect of item 66, my lord. The interim order is operating till the next date of listing. So it will operate till today. It may be extended, my lord.
Due to paucity of time, the case could not be taken up today. First off, the interim order, if any, shall continue till the next date of listing. List the case after a week on a date to be fixed by the office. The interim order, if any, shall continue till the next date of listing.
Can it be 7 December item 45?
7.
7.
Okay. 7. 7 is Sunday. We don't sit.
7. Oh, 26. I am. Lots of 8. Oh,
8. Monday.
But item 55 may have a date, my lord.
Hmm?
Item 55, my lord.
Silo did you? Any interim order anywhere in the remaining cases?
Yes, my lord. Item number 69, interim order may be extended, my lord.
Interim order is there?
Yes, my lord.
Silo due to paucity likhi dibo. After 1 week dibo, interim order if any, continue to the next listing. 69 Silo.